rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. Rise up now, it's our time to shine. United and free. We'll write a new paradigm. United and free. United and free. United and free.
Welcome, everybody. So it is potentially verdict day for Joseph Ferlazzo. It is closing argument day. So this has been a case that's kind of been operating for me in the background of the Harrington case, but I have been following it. I have been watching it. I did watch most of his testimony last night. Haven't got through all of it, but I was watching some of it while it was up yesterday as well. So, really interesting case here for reasons that you have to look close at. You know, on the forefront, it looks like you have a guy here who guns down his wife. It's pretty cut and dry. But I want you to watch that testimony because that's where the interest, at least in my eyes, and my wife is a mental health nurse. And when I had her watching some of the testimony yesterday before she hit the road, and she was telling me that, of course, she has extensive experience. She's been doing this, working with mental health patients for over 5 years. And she immediately said, he is trying to suppress voices in his head. That's what she said. That when he was asking questions, the blank look, the weird affect, and she said, how can these lawyers not be picking up on this? How can the judge not be picking up on this? And I said, well, they may not care, or it may just not be fitting into their defense. But what we saw him subjected to, she was appalled at, because she said someone doing the things he was doing, acting the way he was acting, with the affect the way he was struggling to suppress and hear the questions and get across. So that brought to me, I asked her, I said, do you think that if he is suffering from a multiple personality disorder, do you think then that there was a different personality operating? Do you think that's why the Joe Ferlazzo that's in the courtroom right now isn't able to remember the shooting, isn't able to remember the breakfast? which of course the prosecutor was coming at him at. And she said that's very possible. So I am perplexed as to why this wasn't. And again, I don't know. I did not. This is one of these cases that I have not did a tremendous deep dive into the background of the pretrial documentation or motions, but it's obviously a case that's taken a few years to get to trial, which is unusual where in Vermont, because in that section of the country, they normally will take these cases to trial pretty quickly. So I'm assuming there must have been a mental health aspect to this, but I'm curious as to why the defense didn't pursue that or look into that. Now, perhaps maybe the experts said, listen, he was perfectly, that wasn't in effect, and he wasn't going to qualify for insanity. Perhaps maybe Vermont's insanity laws aren't strong enough. Something I need to maybe dig a little deeper into today as we're waiting on the verdict. But from the standpoint of self-defense, now this is one of those interesting cases that it's how is he going to be received by the jury? When I was watching his testimony, I felt like, I felt like he was being sincere in what he was remembering. I did. Now, do I believe that this should rise to the level of self-defense? If he really in the moment, now the dismembering is a problem, and see that's where the mental health aspect. That's why my wife said when I was talking with her about this, I said, why does he do that? I said, well, that's because when he does this, if he shoots her in self-defense, that's where the mental psychosis comes in, to where that voice in the head says, Joe, you don't call the police, cut her up, put her in bags. People say, how does he live? How is he going back for the few days that he did? Why is he driving around with this body in the bathroom? Well, it's because, he does this, and then he's got, in her opinion, like she said, she believes that he was suppressing voices, that he was clearly showing signs of schizophrenia, that he had potentially multiple personality disorder, and that they were talking to him in that courtroom. What you were seeing there was him trying to push those down and trying to hear, actually, as she explained to me, when this is going on, when you have a real case of this. And again, the interesting thing is, this is why the guy that comes in and testifies or tells somebody that he has it, they're the ones that are insincere. It's guys like him who are actually showing the physical attributes and the way they're acting and what they're looking at. And like I said, she has a large amount of experience. She works around this every day. But she said she could tell, based on what she was seeing, that he was trying to push those voices down and stay in the moment so he could try to remember around that. And it actually can be so disruptive that when they're asking the question, they can get in the way of the question. He's trying to, she said she could see it. I mean, why would this had to be part of some evaluation. So I don't know. I need to look into that, see if I can dig anything up and see if maybe he was evaluated. Maybe they said, well, it's not that. Pulling a gun out, or he perceives it, or whatever his perception was at the moment, and he shoots her right after the fact when he's trying to make decisions on what to do, because now he has a dead wife who's shot. That's when the other voice, this is how you're going to, Joe, do this, or whatever, however it works for them. I don't know. I don't make sense of background in that. But the point is, I found that interesting. So I'm curious to see how the jury receives this guy, whether or not they're going to, feel like there's a valid self-defense claim here or not. And then the question is, let's say he's found not guilty. That's what I said. He's a danger. She said, oh, he's absolutely a danger. If he gets out, this is prone to happen all over again. So this is where, again, we get into this whole thing where we don't allow mental health to be a bigger part of this, because we have a guy right now who's got attorneys there. Attorneys his attorney at times seems a little slow, a little behind, a little bit like she might be a few years past her prime. But then at times, right now, which we're a little behind the live right now because they're working on jury instructions. Um, you know, she seems to be on top of it. Very difficult for the jury to probably see past some of the things that I was just talking, like why did he cut her up and stuff like that. I think what the state's going to focus on. But let's just say he does, or let's just say they decide to convict him of something lesser because they say, okay, it's clear this lady hits him with a Yankee Candle, and she was there was some sort of domestic situation that drove him to do this, but we don't think it was clearly self defense, but we think, they have guns. There's clearly guns in the thing, but he's going to get back out potentially, and he's going to be sent to a prison to where he's. This is the type of guy that dismembers his cellmate, and perhaps nobody's worried about the safety of a prisoner, but if your loved one was in there, you would be. And we have a doctrine against cruel and unusual punishment. Not to mention, it's cruel and unusual to put somebody in that environment without treating their mental health issues. So where the breakdown came for this man, and I trust my wife's opinions and what she looks at, because she's normally pretty on point. Like I said, she has a vast amount of experience as a nurse who's around people like this gentleman all the time, right? It's where she spends majority of her days or work days is around these people. And she was seeing it, and she was pointing it right out to me. I wanted her to come on and talk, but unfortunately, we weren't able to arrange that because she's still on the road. So, but I just want to come on and say that because that is what's got me interested in watching what this jury does. Interested in for several reasons. One of them just general concern for society that we might be on the verge of releasing the guy because suppose they believe him. I mean, I found him to be compelling. I found him to seem sincere. Now, again, um, to me, I think there could be a situation where they come in with like, well, my concern and would be on the lesser, right? That he gets convicted of something that allows him to eventually get out. Because if he gets convicted at the top end of this, then it's life and he goes away forever. But I could see a jury on this, having heard his testimony, and I believe that's exactly what this defense attorney is trying to do, and is in hopes that they come in for a lesser. And then it's not locked away forever. We have to deal with this guy. And can you imagine a guy with these type of issues getting out eventually and coming out? And he'll be 10 times worse than what he's at. And the question is, again, I don't know. I have to look into it. Why has this not been dealt with? Why has this not been addressed? Why did we have a guy with apparently a very apparent mental health issues sitting on a witness stand who may have been batting down voices inside of his head and trying to listen to the questions and has a blank stare and clearly had a very unusual affect, which I just took as I was like, what's the deal with him? But you could see, as my wife pointed out, a lot of people who suffer from those type of situations. It's why they drink. It's why they do pot. As he was mentioning, that settles down, that levels them out, and that's how he's trying to treat it. But also, when you're dealing with pot and you have schizophrenia, it is, as has come out in other trials, that could sometimes be something that really takes it to the next level, sets it off, and can really be problematic. And in this case, maybe is perhaps how we got to a situation where he's shooting his wife, dismembering her, living with the body for a few days, and doing things that are just absolutely unusual and out there, and yet very, in my opinion, sincerely claiming, I don't remember this. I didn't know this. So I think it's I think it's an interesting situation. But and I like I said, I think that there is a path here that this guy, things could shock you. I'm sure. Let me ask you this, Ann. Yesterday, did did you believe Tim Harrington was going to be on a hung jury? Did you believe he was going to be still home and free today? If you watched that trial, there was a lot of people that did. So juries can do interesting things. Um, and that's what I fear, and I certainly fear this guy getting out because I think he's a danger to society if he gets out. So we'll see what happens today. It's going to the jury. Perhaps the jury will come back and just throw the book at this guy and lock him away. And then, like I said, I still think there is an obligation to him to get him treated for some things while he's behind bars, and save us from reading about the guy who dismembered and ate his cellmate, um, which is something that nobody needs to see, nor do the jail officials need to walk in on something that gruesome. But this guy strikes me, if he goes in there untreated, and it sounds like he's going to, if he gets convicted, and I think there's a strong probability he'll get convicted of something, but whether it's the thing that takes him off the streets for the rest of his life, or maybe something that gets him out for 20 years, maybe at sentencing, maybe we'll hear things about the mental health aspect, and maybe that'll be something that can come in. Again, I have not done an extensive deep dive into Vermont law when it comes into that. Something I need to do. Like I said, my main focus had been really looking at the Harrington case with the other cases operating. So with that, we are going to jump into the courtroom here now and pick up. We're going to be running a little bit behind the live, which means when the judge inevitably takes one of his 4 to 5 breaks that he'll take as we're going through closings and going through this process, we will eventually get caught up, I promise you. But for now, we're going to pick up. They're going to be discussing the law right now. They're discussing jury instructions. So, again, I'm not certain in Vermont if we will hear jury instructions prior to closings or if it will be after. We will find out, I'm sure. But I'm quite certain there will be enough breaks that we will eventually get caught up here. Unfortunately, if they had found his body, maybe a different outcome. Well, and yeah, potentially, but I think the body was a big problem, and I think it allowed for his attorney, who was a very very good attorney, to make some arguments. And I also believe, again, we don't know if it was 11-1 guilty or 11-1 not guilty, but I also believe that there was just some arguments made in that case that were made in a way to speak to what Kevin Horan knew was going to be a Southern jury who were going to have certain potential biases and ways of looking at things. And that's what he appealed to. And the way he took those Snapchat messages and essentially almost made them his own evidence and turned them against the victim and said, these were, instead of being evidence of, Tim Harrington trying to lure him, it's like, this is evidence that Jay Lee was the aggressor, was the guy who shows up at his house and then is threatening to out him. And it was a masterful job. And then, of course, you've got two things which inexplicably why the state would not have just had someone there to address these things. The key audit log, and then, of course, the key report on the card, the Bernot report, or however you say it. Both of those things, they should have just had someone there to say it's not credible. And then it wouldn't have been something that they could have held up in front of the jury and tried to raise doubt, because, of course, all the defense has to do is say there's a doubt. If this report's accurate, Tim Harrington might not be guilty. If this report's accurate, Tim Harrington might not be not guilty. The state didn't take the time to show what it was. They just threw a witness on the stand who isn't certified, who isn't an expert in this, and says I was told it was not reliable. But are you supposed to believe that in a capital murder case that involves a man's life? And guess what? That at least either 11 came back and said, we agree with you, Mr. Horan, or 1 came back and said, I agree with you, Mr. Horan. Doesn't really matter today because Tim Harrington's at home sitting on house arrest. Jay Lee's family's got to go through a whole nother trial now. And now who knows when this thing goes back to trial, because, like I said, they've got a tremendous issue that I know will be explored, and I'm quite certain will be taken to the Supreme Court of Mississippi to have them look at it, and that is going to be whether or not they can move forward unless the state backs off the kidnapping. And it still may be something that they want to have the appeals court look at it, because it's whether or not the indictment is defective, and whether or not jeopardy attached to that indictment, because the state chose to move forward without double checking to ensure that they had the amended indictment filed. I mean, inexplicable stuff in a case of that magnitude, but it is what it is. Anyways, we're going to the courtroom, guys, and we're going to, next place you'll see me is over in the beaten child case. We're going to be launching that one here in just a moment. That one is going on today, and I'll see you guys over there. So let's head to the courtroom.
Thing.
Just starting to
Having in mind, even if you read through it, there are certain struggles that I'm having to make sure I tweak this right. And some of it is there's some confusion in the law, but we'll go forward. We're here in the matter of State versus Joseph Ferlazzo, 21 CR 8967. Mr. Ferlazzo is present with his attorneys, Ms. Jansen, Ms. Johnson, and the state is present through Ms. George and Ms. Adams. We're here to discuss proposed jury instructions. The court has received proposed instructions from the defense back in November, and the state's response yesterday seeking to tweak some of them and remove some of them. And I guess one question I have for the state is, obviously your revisions or requests to deny were made before you heard Mr. Ferlazzo's testimony. So the first question is, are you still seeking to have no instruction on voluntary manslaughter?
No, Judge, I think that our appellate folks think that the voluntary manslaughter, there's probably sufficient for that. It's the involuntary manslaughter we are certain.
That's good. And I would point us to Yo and Delisle and Belaski, all of which, Yo and Delisle particularly, did not seem to have an extraordinary amount of support for it, and the Supreme Court was still pretty clear we needed to instruct it. My next question is this. It has always, the absence of great provocation language has always been addressed in second-degree murder cases. The language of the court has been broader than that. But in Yo, maybe paragraph 23, it talks about that a finding of premeditation and deliberation necessarily precludes a finding of great provocation. I don't know whether I read that to mean you don't give it in the first because it's already embedded in the definition, particularly of deliberation, or whether you still give it in first degree. And I couldn't find, I don't know if you have it back in your files, Ms. Jantz, from when Jerry Schwartz tried the case, but I'm wondering if you know what the language of the first degree was.
I don't, Judge, but I did speak to Attorney Saxman. She's the one who was the appellate attorney on Belaski, because we've talked about how there's no rational, logical distinction between first and second degree in terms of the passion, provocation, instruction. And that the only reason it wasn't addressed in Belaski is because he was only charged with second degree, not first degree. In Yo, he was charged with first degree. And I have in front of me, murder and manslaughter are both lesser included offenses of murder in the first degree So I think that there is, and that also refers to Delisle. Voluntary manslaughter is an intentional killing committed under extenuating circumstances that would mitigate, not justify the killing, such as provocation that would cause a reasonable person to lose control. And there's no distinction between degrees of murder. So I think it's appropriate in both the first and second.
So you don't think it's necessarily included? I almost wonder if it's better done as a subset of the deliberation instruction. It's awkward to me to think, since Yo speaks directly of the fact that if you find premeditation and deliberation, you're necessarily not finding great provocation, it would almost seem it's best to include as a subset of those rather than a separate element, because it doesn't make any sense as a separate element when they're addressed through premeditation and deliberation, as opposed to second degree, which it's the intent element that it is understandably a separate element.
So my one goal is to make it as clear and not confusing to the jury as possible. In both, our understanding of the law is that in both first and second degree, the burden is on the state to prove beyond a reasonable doubt the absence of passion or provocation. So even if the state were able to prove all the other elements of first-degree murder, they still also have to prove the absence of passion or provocation in order to convict on first-degree.
No, I appreciate that, but since
where
we
to
know
put it?
from Yo that you necessarily are concluding that if you find that's premeditated and deliberate, it seems to me it's better as a subset of, I'm not saying you're not entitled to those words. I think you are, given, and that's what I've been going around in my head. It is of Yo, but because one way you could read it is you don't have to do that because it's already kind of in I think that necessarily follows, but it is what the law says, and they've said it a number of times. So I'm not. You don't have to push me on that, Ms. Jantz. It's an interesting question, though.
So, and just, I hear the court, you're already there, but we discussed at length whether it should apply to first degree in addition to second, and the case law makes no distinction, and it shouldn't.
The case law hasn't really dealt with it.
That's right. So it is something the state has to prove with respect to first degree murder as well as second degree murder, that there was an absence of passion or provocation.
I guess the question I have for you is, in cases I've seen of first degree, it's always just got the language regarding premeditation, what premeditation and what deliberation means. And those definitions at least seek to say that sudden impulse, and if it's done under sudden impulse or without thoughtful deliberation, they haven't proven it. And does that not cover it to some extent?
I don't think.
Well, to some extent it does, but does it cover it
because
completely?
I think the language from Hampshire is what we need. That the state must prove beyond a reasonable doubt the accused did not kill under the influence of passion or provocation. The burden's on the state, and beyond a reasonable doubt. And that's, I know it's not a statutory element, but it's been added through case law that is an additional, I don't even want to use the element, the word element. It's an additional thing the state has to prove in order to get a conviction for murder.
But isn't Hatcher second degree?
Mm-hmm. Yeah, they're all second degree cases. That's why, except for Yo, and I don't have the instruction in Yo as to what, but my educated guess is that it wasn't included in there. I mean, there was no manslaughter instruction in Yo, which was considered error but harmless in the case.
Was it?
But I don't know what the first degree instruction was.
I don't know the instruction, Judge, but I'm just looking. Was there testimony about it?
It's not. I mean, I had something to do with the O2, and I don't remember that specific issue coming up. And I don't see it in any of the reported decisions.
So I'm looking at Yo and distinguishing between first and second degree. I'm looking at paragraph 15 and 16, and it says, without more, though, we would still reverse appellant's conviction if the jury had chosen to convict him.
Right, of second.
Second degree. So, but they convicted him of first degree.
Right, but that's what I'm saying. It because they necessarily find that a finding of premeditation and deliberation negates the great provocation. So the inference I drew from that is that those instructions on that were sufficient, and at least at that point, there's argument to be made that it's not as clear as it should be if we've got the absence of great provocation, which is better suited in the second degree. It makes more sense there just because it's an intent issue, and we're saying, yes, it's intent for second, but yeah, if there's great provocation, that intent, it's reduced to the manslaughter. But that's only in the context of second, because first degree precludes, given the finding of premeditation and deliberation.
Well, we still think that it should be included in the instructions regarding first degree. I understand the court's distinction on the issue of intent, but I think it goes directly to whether there was premeditation and deliberation.
Yeah, there are cases out of other states that kind of go both ways. California's, but it's a 1931 case, seems to support that it should be in there. Other jurisdictions, not quite as clear. All right.
Does the court want us to go through page by page?
Yeah, I wanted to bring that one up first because that to me is the most, that and the involuntary question are probably, I do think there's a voluntary, I was concluding a voluntary manslaughter instruction was appropriate. This is an interesting case. Might have been more appropriate through what Mr. Ferlazzo says in his interview than it was in what he said on the stand, although because there wasn't really a connection made between past conduct at either on the night of the incident or preceding the incident in his testimony that led to the shooting under the testimony that he gave yesterday. When I thought further, I said, well, I guess a jury could think that he thought a gun was coming out, and she was saying things, and there's great provocation, but not sufficient for self-defense. So even on the state testimony yesterday, I think that it probably has to be given, and maybe even more directly, given a jury's ability to make that distinction if they wish to. On the voluntary.
Yeah, I did ask Attorney Johnson in our office, who I think did the Yo appeal, if she has the instructions. She's looking for them now. She thinks she does. So we want to go through the rest.
That would be great. Thank you.
Get them.
That would be great. And why don't we do you both have in front of you what I sent?
Yes, I do.
Yes, Judge, we do.
We'll see there's some yellowed parts too.
On page 1?
Not on page 1. I'm getting back to page 1.
Okay.
I was on a different page. All right. So page 1, let me just say what I did do, which I don't usually do. I don't usually do the charge on page 1. I usually do it before I do the elements of the crime. But both of you asked for it there, so I put it in there again. And I added Mr. Ferlazzo has pleaded not guilty to the charge. State didn't request it, but the defense did. So if you want it there, that's fine. Any objection to page 1?
No.
No, Judge.
Okay. Page 2.
No objections.
No objection on page 2.
All right. Page 3, and I'll just note for you, Ms. Jantz, I think I moved the reasonable doubt instruction from where you put it to where I usually put it, which is closer to when I'm reading the elements of the crime.
That's fine.
Okay. So this is the evidence and circumstantial evidence piece, and Ms. George, I did not include your last sentence regarding Mr. Ferlazzo, but I just didn't think it was necessary on the circumstantial evidence.
I have no objection to page 3.
Into page 4, let's do the whole circumstantial evidence
Yes, that's 3.
No objection.
All right. Page 4, credibility of witnesses.
No objection.
Let me just take a quick look. Looking at the reasonableness of the testimony of the witness considered in the light of all evidence in the case, and I think that is ambiguous and maybe confusing. I don't know that.
Me too.
We did. Ms. Johnson's telling me that we had it, so I'm going to leave it alone.
It was in
That was
your
us.
instruction.
Okay.
Yeah. So no
Let me
objection,
just
or is
I'm
there?
not finished reading.
What's that?
Just one more second, Judge, please.
Yep. Remember, there's a fan going on in here, so try and keep your voice up.
Oh, okay. That's fine. Page 4 is fine.
All right, no objection to page 4 from either party. We'll move on to page 5. Are you still reviewing page 5?
Yes, so
Okay.
your yellow highlighted.
In 5?
That's on 6.
Oh, we're
I
on
think
6.
that's on 6.
Oh, 5 is fine.
Okay.
I apologize. I was on 6.
So the yellow highlighted is in the model instruction. I didn't know if it was particularly relevant in this case. It did not seem that that's where you were going, but it is in the model instruction, and usually the primary basis for why statements would or would not be found to be involuntary. But does the state want it in? I'll start with you.
Yeah, I think that the one above it, Judge, covers it. There's no evidence of any of that in this case, so I don't think it's necessary.
I tend to agree, which is why I put it in yellow. And I thought you also might not want it because it might focus too directly on something that may not be your strong point.
So I don't agree that it's necessary to have the sentence that begins, if you find Mr. Ferlazzo would not have made statements, ending, person accused of a crime that are, I don't think any of this is necessary. However, the court did not include what we asked for, which is that you may also, so what we asked for is if you find Joseph Ferlazzo would not have made the statements but for some threat of harm or punishment or promise of leniency, then you may find the statements not voluntary. The sentence that we asked for was, you may also find the statements not voluntary if you find Joseph Ferlazzo was not thinking clearly and rationally because of his mental and physical condition.
Yeah, that's not the law.
Well,
So, and in
case
fact,
law-
State v. O'Neill, I think, was cited in Judge Griffin's opinion, and it says specifically that's not sufficient.
One second.
So there's got to be some police involvement in this. If it was always just being, first of all, I don't know what rational necessarily means in that regard. I mean, if you found that he was in a psychotic state, that might be basis, but I think it's way too broad to suggest that if you find that he wasn't or wasn't thinking clearly,
Well, then if
that's just not a standard of voluntariness that the Supreme Court's ever supported.
If that's the case, I do object to the court's ruling, but I then would ask that you remove everything that's in
All right.
yellow highlight.
I think that makes sense. We'll remove that. In fact, let me do it right now from mine. And it really is the remainder of the model instruction, I think, without that part. Anything else on page? There's only the number of witnesses, the other thing on page 6.
No, Judge.
Did you remember, Sarah, what about your stipulation concerning the pillow that you sent? Didn't you email us this morning about changing that stip?
What does that have to do with 6? Is it on
No, it's not in here, but
there? Yeah, stipulations in the next page.
yeah. So Judge,
Yeah.
you have in yellow highlight, add gun/bullets.
Well, we said we were going to give everything to them.
Right.
And we're not
Not
giving
gonna
them
give
everything.
gun bullets.
So I wanted to know how we wanted to.
I guess, Judge, from my perspective, the bullets are the only thing I don't think should go into the jury.
You want the gun to go in, but not the bullets or magazine.
Yeah, I mean, I think that part of our argument is that when Mr. Ferlazzo admitted that the silencer is on it.
I don't mind. I don't. At the time, you said both, but I understand the difference. I don't want anybody to have the ability to do anything harmful
Agreed,
with the
yes.
gun.
I absolutely don't think the magazine or any of the bullets should go in.
Okay.
I do think the gun should.
All right. So you're asking that so then we still have to deal with that. I don't suspect they're going to really care about the bullets. No. The PowerPoint, on the other hand, do you have an exhibit other than that screen shoots the PowerPoint or otherwise has it in documentary form? Do we have that? Or
PowerPoint?
the one that,
Yeah, the court has that on a thumb drive. I don't have it as a PDF because they're movies,
yeah.
so I don't know.
Yeah, typically we play those in the courtroom.
Yeah.
So that's all that, I'd probably add
I
that,
assumed, yeah.
okay? That there are 2 exhibits, the PowerPoint from, what was her name?
Carrie Fiore,
Fiore, right.
and then the interview would also, I assume, come back out.
Yep. But they will be getting the transcript of the interview.
Yes.
Yeah, I mean, there's a number of audio recordings that were admitted. Cody, the second one in the cell, all of that, they'd have to come into the courtroom to.
Sounds like it.
Okay. So we'll kind of tweak that a little bit more and get it back to you. Anything about the rest of page 7?
Do you want to tell them about the
So
stip?
Judge, we do have the corrected stipulation, and I don't know if the court wants us to just swap them out, but we can do that.
Unless you have an objection to it, we'll just note the number, the exhibit number, and add that it's corrected in light of the fact that the exhibit was introduced in evidence.
There's actually, I don't know, if we sent 2 to defense this morning. There was another one that while the court was reading it, we noticed an error, so.
Well, there were a couple of times when you had the fact in the.
I don't know that we fixed that.
I tried not to read both the facts, but
So we can, I don't think it needs to be included in this. I think we can just swap them out.
well, that would, unless
fine.
it seems to be a ministerial
Housekeeping.
and not a substantive issue, so we'll do that.
Nothing else on that page then, Judge.
All right, and just make sure we do this. You know what I should, after this, Ms. Jentz, make sure I ask you if you have any further motions in the case. Okay? And I do, for the record, I understand that the evidence is now closed, is that right?
That's correct, Judge, yes.
Okay. So if you have any additional motions, we'll take them up after we do the charge, okay? 8.
I know. That's not what he's talking about.
I know, he's talking about additional.
And on this, Ms. Jantz, it's the model instruction on burden of proof, but I wondered if you wanted,
Oh, I'm still on personal knowledge of juror.
oh, okay, okay. All right.
I guess, did we have this? Personal knowledge. I don't know whether he had it. The sentence, the last sentence in the first paragraph, you may use knowledge and experience which you possess as intelligent persons.
As intelligent persons.
So, I would just say you possess in weighing the evidence. I don't like this.
We don't want to presume anything.
Correct.
What are we removing?
I think she'd like to get rid of
Intelligent
as
persons.
intelligent persons. Any objection to that, Ms. George?
Seems harsh, but no, I don't have an objection. No, that's
It
fine.
seems,
That's fine. That's fine. I don't think it's, again, it's not a substantive change. We'd certainly not like them to use knowledge they possess, though, as unintelligent persons.
you can't.
We'd rather, I think it highlights the fact that you should really be thoughtful in that knowledge as opposed to rash or speculative.
That's completely different, and their intelligence level is what it is. To presume they're all
If you want that out, we'll just take it out.
I mean, if you want to say something about giving care, and I think you do later on, or already have, careful and thoughtful consideration, I don't think we need to repeat that.
Really, I think the whole point of this paragraph is to get to the next paragraph, which is don't consider things that are outside of, don't use special knowledge to address things that no one else would have
Right.
access to. So we'll just remove as intelligent persons, given the request by the defense and the lack of objection from the state. And move on to page 8, or the rest of page 8, I should say.
No objection.
In this regard, Ms. Jantz, I was going to ask you, it is part of the model instruction on burden of proof to have or to testify in his own behalf. He is not required to call any witnesses or to testify in his own behalf. Do you want that to remain in that phrase?
Yes.
Okay, and it will. I'm sorry?
I tried some language on stipulated.
we still reviewing page 8?
Yep. So, Stacy, where in our instructions? Page 2, reasonable. So, it looks like we didn't include it in our submission, but I have had it included in other cases that jurors doubt they need not articulate it, and they need not, it need not be the same as another juror's. I can draft up some language that I think I have some earlier cases, but I would like them to know that they don't all have to have the
So
same.
what I suggest, rather than arguing about it, neither of us know what language you're
Yeah, yeah.
proposing.
I'll
So if
give you
you
something.
have language that you
I
think
will
has
give
been
you
used in
something.
other cases that you think is supported, you should write it up
I
and
will.
get it to us. Okay, so why don't we skip over, unless there's anything else about the reasonable doubt charge that you object to. It sounds like you may wish the court to consider adding something.
I do want it added, but I'll draft it and send it to
All
everyone.
right. I do note this is consistent with what you submitted, right?
Yeah.
All right. We should move on to 9. And I have in mind in page 9, you're wanting something about, which we're not fully dealing with yet, something regarding absence of great provocation and sudden passion. Or heat of passion, not sudden passion. Well, it is really the same, I think, for pre-deliberation. Are you still on 9, or are you?
Oh, no, I'm sorry, I was on to 10.
So
I'm good on
9,
9, except for burden of
whether it's okay. So 10, you'll see I put in brackets something about an inefficient intervening cause would be an unexpected. Is that something really at issue in this case, and do we include that sentence?
I don't think we need it.
Ms. George?
Well, in brackets, a killing may be, which one are you talking about?
The first one.
First essential element, right?
Where it talks about death in a
Efficient intervening.
natural and continuous sequence
I don't think we
unbroken
need
by.
it.
What?
I don't think we need it. It's
Ms.
not a
Ms.
fact in
George?
this case.
I mean, it's part of the model instruction, I'll include it unless both sides.
We don't need that, Judge.
Okay, then we'll. You'll see I added a bracketed statement with regard to the term unlawful, which is not in the model instruction, but it seemed to connect the killing with the self-defense charge.
And is supported by the case law.
Fine, Judge.
Okay?
Objection.
And then we'll leave that in under 4. Anything else on page 10?
No.
I'm sorry. Did you answer, Ms. Jantz? I didn't hear.
I said no.
Okay, thank you. We're putting that in the bracket. We'll come out and we'll move to page 11.
Just a typo. Page 11, in the last sentence in the 5th essential element, the state must have proven that he actually thought about killing Ms. Ferlazzo before he's missing.
Thank you. And I would just ignore what I've put in so far. I don't think it would be, either party would like it very much. I think I do want to wait a little longer to see if we get something on you, but I think I would work on that. But it would be the court's intention, to the extent it adds something on great provocation, that it do so there and not as an element of the crime, because I just have not seen it. But I would probably include that it has to be absent beyond a reasonable doubt.
Thank you. That's.
I mean, I'll just connect the concepts.
Yeah.
That would be.
So what I'm asking for is what's in Hampshire, where passion or provocation is implicated, the court must instruct the jury that to establish murder, the state must prove beyond a reasonable doubt the accused did not kill under the influence of passion or provocation. That's a quote from Hampshire, paragraph 7 and 8. That's my request.
Yeah, I think passion or provocation is too. The term is much, I don't think that's actually right, and I think they suggested that Judge Katz didn't quite get it right in how he did it. You know, it wasn't as artful as it could have been. I think the terms have to be much more consistent with what the instruction is regarding voluntary manslaughter, that the provocation has to be great and reasonable under the, there's language that I think you have to put in, otherwise
So
any passion, someone enraged, for example, might have great passion and might feel provoked, but that doesn't mean it's justified as to reduce from first degree. And they might, in that rage, say, I'm going to kill somebody and this is how I'm going to do it. So I think we have to be careful to make sure that we narrow it sufficiently that folks understand that it has to be consistent with the terms in voluntary.
I understand. I'm looking at Belaski. It doesn't say great provocation. It says adequate provocation.
I'm going to look more at the model instruction, try and keep things consistent, because if we don't do that, we get mixed definitions, and that's confusing, I think, to the jury.
Well,
But I mean, why don't you wait until you actually see the language?
Yeah.
There'll be plenty of time to object or to speak further on what I've done. I'm acknowledging I haven't gotten it right here. And the state will have the same opportunity to weigh in. I'm sure the state wants to look at Yo first if you've got it. And
She hasn't located it yet.
yeah. Okay. I think so. It seemed to me that self-defense was better put after first than it is at the end. You put it at the end, but it seems that's where you're considering it. If the court's considering second or manslaughter, it means it's really rejected self-defense, right?
I agree, Judge.
Any objection to it being there, Ms. George? And then you can read what we put to see. You'll see it's not what you requested, Ms. Jantz. The subjective, objective thing,
Well,
well, why don't you read it? And then you can make your record or try to convince me of something more.
where's the court directing me to look?
I'm sorry?
Where am I looking for the standard for self-defense?
It's all through page 12 and 13?
Okay, 12 and 13.
Yeah.
Oh, okay. Sorry.
And actually ends on 14.
Stacy, where's our self-defense?
Okay, page 12 and 213.
So I do object to this, Judge. I do think the case law supports subjective and objective standard. I'm looking at Wheelock, and there it is. And the quote, and let me see if it's in here. A jury must assess the reasonableness of a defendant's apprehension, taking into account not only the circumstances with which he's confronted, but his individual attributes as well.
Right, so
And if you have that?
the statement we have is when assessing the reasonableness of Mr. Ferlazzo's fear, you may consider the individual characteristics of Mr. Ferlazzo and Ms. Ferlazzo, such as their respective size, gender, age, physical condition, strength, stamina, courage, assertiveness. I guess we could,
So you're talking-
and other personal characteristics, I guess we could add.
Well, yes, because size, gender, age, physical condition, strength, stamina are all physical, not emotional or any
Well,
other kind of
courage
something.
and assertiveness are
Courage
more
and
emotional.
assertiveness,
We have that in
we had that?
there.
It's fine if we had it.
You had that exact language, right? I mean, the reason you have it is because it's modeled jury instruction.
Yeah, I agree, but.
I'm trying not to get overly
I don't-
creative.
I think citing all of these physics, size, age, gender, physical strength, the issue is his perception of the circumstances.
And the reasonableness of it, not his perception. It's the reasonableness of
reasonable
his
person,
perception and
given
the accuracy of his perception.
Given who he is. I think the case law clearly supports that based on his psychological.
Well, if you have another term you want to include in the such as clause, why don't you think about that?
All right.
But I didn't see, frankly, obviously I'll state the obvious. There was no expert testimony here regarding Mr. Ferlazzo's mental state that might suggest that because of his history, he'd be more inclined to be reactive. So we don't have any evidence such as that. There is no burden on the defense to have any evidence in a criminal case. So, but it does go toward would there be some reasonable inference created by the fact that Mr. Ferlazzo, I don't know where we're going with it. The evidence was very limited in terms of what his personal history was as a kid. And frankly, we let you put in as much as you wanted to regarding his relationship with Ms. Ferlazzo, but there was very limited connection made between that former alleged abuse by Ms. Ferlazzo and why he engaged in the conduct he did that led to her death. In fact, it almost became irrelevant because the claim was she did something so unexpected that I was thrown off guard, and I never expected she would do that. Nothing in our history suggested that, but she did it, and I just reacted. So you've got all that in terms of the history of Ms. Ferlazzo and Mr. Ferlazzo. Whether it turned out to be relevant given the way in which the testimony came in, you can each make your arguments, but I'm not going to limit it. I'm not going to strike things, but it is questionable.
So, Ms. Johnson is pointing out that what we submitted with respect to the sentence I'm having trouble with is
there is a subjective and objective component.
Yes, in addition to that, when assessing the reasonableness of Mr. Ferlazzo's fear, that sentence, in the version we submitted, it includes as well as their relationship history. And I know you've referred to that before, but I would like it included in that sentence as well.
Okay, say that again.
So,
I'm sorry, I've been handed, and
Let's
because she is amazing.
page,
Who did it?
Someone in the office downstairs.
We found the first degree instruction in Yo.
Oh, amazing. Great, I'll tell. Pam's like calling archives every time, so call her up. They were in the evidence box.
he's not listening, he's looking at the instructions.
The first degree murder instruction would never pass now.
We were thinking about that, with how old it is.
It says willful and deliberate means that defendant decided and specifically intended to kill Miriam Yo, and that the killing was not the result of inadvertence, mistake, or accident. It's really much more about specific intent to kill. And has nothing about a separate element of deliberation. Then premeditated. There's nothing in either the first degree or second degree regarding this idea. It's very interesting, just nothing in it regarding the absence of great provocation. So, and Yo is after Hatcher, so it's, that's why I said I was confused by Yo. Because there is that language that necessarily finds that there wasn't great provocation, so with the absence of language, that might support the idea that it wasn't necessary to give. On the other hand, the instruction on deliberation seems to be inconsistent with any instruction regarding sudden impulse, which now is in the instruction and is more consistent with absence of great provocation. So there's actually more given in the instructions now than was given in Yo for a jury to conclude that there must be an absence of great provocation. But Belaski is well after Yo. So, sometimes, unfortunately, in these most serious cases, just like the transitions that went on with what is voluntary, diminished capacity, and voluntary Congress and the cases before it, there's a lot of different statements provided by the court. And we're here to try and clarify them. All right, I think I'm just going to need to think about that more. We can make a copy of this for both of you when we're done here, so you have it, so at least arguments can be made. All right, and I'm sorry, I interrupted.
That's okay.
You, in terms of, you said we did it once before, but you wanted it included here too. What was that language you're referring to?
So in our submission, the third paragraph on page 13, when assessing the reasonableness of Mr. Ferlazzo's fear, you may consider the individual characters. The end of that sentence we included, as well as their relationship history.
As well as the relationship history.
You've already talked about that, previous interactions, but I think it is necessary because that sentence focuses primarily on size and gender and age and strength. I would like, there's the courage and assertiveness, but
isn't that paragraph right before dealing with this exact thing?
Yes, I said, but I want this sentence to include that as well as their relationship history. Because you're pointing out specific attributes, size, gender, age, strength, and I wanted to be clear that it's not only those factors. I know you've said that.
What if we just, instead of using any previous interactions, since that usually covers folks like who don't know each other, why don't we just including, you may consider their relationship history?
In the previous
paragraph.
I understand. That's fine, relationship history. I still don't, it may have been what we submitted, but I don't like the sentence that identifies gender, age, physical condition, strength, stamina.
Yeah. But all those things are part of it as well as the relationship history. I think
fine.
In the context of this case, I'm not convinced that the relationship history is particularly relevant to what he, it's relevant perhaps to what he said in the confession at the interview, in terms of where his head was at. There I saw the nexus. I didn't see it that much in the testimony he gave yesterday in support of the self-defense claim. But any objection to changing previous interactions with relationship history?
No, Judge, but we would object to it being in the next.
I'm not going to include it in both places, given the limited nature of the relevance just indicated by the court, but on a self-defense theory. But we will change any previous interactions to, you may consider their relationship history.
So grab this again.
And I guess we'll note whatever objection you have to the, yeah.
Where are we up to?
Is there anything else you wanted to put on the record regarding self-defense?
No, Judge.
No.
All right. Then we will move on from pages to page 14, I think it is, 14. You'll see I highlighted something neither of you, I think, asked for, but I thought it might be helpful for clarification purposes. And I also note we're dealing with a soft transition language rather than hard transition.
So I'm scrolling through the lesser included to see, I would,
A little louder if you could.
oh, I'm sorry. All right, so let me go specifically. I'm sorry if I'm not, tell me, you are telling me if I'm not speaking loudly enough. The last sentence on page 14, as you consider the mental elements for the lesser offenses, you must also consider whether his mental state was influenced by extenuating circumstances such as sudden passion or great provocation that would have caused a reasonable person to lose control. I was scrolling through to see, and I would like included for each of the lesser offenses, the statement I read from Hampshire, that where passion or provocation is implicated, the court must instruct the jury that to establish murder, the state must, so at least for second degree, must prove beyond a reasonable doubt the accused did not kill under the influence of passion or provocation. That's, I want that in somewhere. I think this is a reasonable place to put it in because you are all you're saying is mental state by extenuating circumstances that would have caused. So I think at that point it's reasonable to include the language from Hatcher. So we're talking about the sentence that begins on the last line of 14, as you consider the mental elements for the lesser offenses. You must also consider whether Mr. Ferlazzo's mental state was influenced by extenuating circumstances, such as sudden passion or great provocation that would have caused a reasonable person to lose self-control.
We have that in, are you reading from ours now?
Yeah,
Okay.
yeah, and after that is where I think it's an appropriate place to put where passion or provocation is implicated. The state must prove beyond a reasonable doubt that the accused did not kill under the influence of passion or provocation, at least for the second-degree murder charge. And if you want to just leave that to the end of second degree, that's fine too, but I want that in there for second degree as well.
I think it already is on page 16, Judge. You have, even if the state has proven the first four elements of second-degree murder, the presence of sudden passion or great provocation could mitigate the killing without justifying it.
It doesn't say that it's the state's burden to prove the absence of it beyond a reasonable doubt. We're on page 16, Judge.
It is the fifth element of second-degree murder in the model instruction.
I can't hear you.
It is the fifth element of second-degree murder in the model
Right,
instruction.
no, it's there, but it is indicated as an element here, which at the end, we're going to say the state has to prove all 5 elements beyond a reasonable doubt.
It's specific, on 17, it specifically says that we have to prove that beyond a reasonable doubt that he was not influenced by sudden passion or great provocation. So I think it's covered.
Yeah, it is there, but I think it's a little confusing. When they're considering each of the lesser included, I'd like it specifically referenced for second degree. Am I missing it? Is it somewhere that I'm not seeing?
All of page 17 is covered.
17, okay, let me see. What I'm not seeing is that it's the state's burden to prove the absence.
Right.
Is that the specific language from Belaski?
Well, it's specific language from Hampshire, but
Absence?
I'll read it again. Where passion or provocation is influenced, the court must instruct the jury that to establish murder, the state must prove beyond a reasonable doubt the accused did not kill under the influence of passion or provocation, citing to Duff. And this is Hatcher, paragraphs 7 and 8.
Yeah, so I think that's captured in this instruction like 3 times.
Oh, okay, but
I really do. I think, and at the end, all of the elements of the offense, and we're including extenuating circumstances, or the have been present at the same time. So, going back to what we said, when he calls it was not influenced by such as sudden passion or great provocation that would have caused a reasonable person to lose self-control.
But I'm specifically asking for the language that the state has the burden of proving that beyond a reasonable doubt.
It's in there at the end. I mean, I think it.
Can you point me to the-
Once we make it an element, we say all 5. The state has the burden to prove all 5 elements beyond a reasonable doubt.
So are you looking at page 16, the sentence that begins, even if the state has proven the first 4 elements, the presence of sudden passion or provocation? The jury...
Well, that highlights it yet again, but
Yeah.
what I'm really looking at is all of the elements of the offense must have been present at the same time. If the state has proven each of the essential elements beyond a reason, then you will be done with, we should have had something if they have not proven all of the elements beyond a reasonable doubt.
That's in the transition.
It's, yeah, we can put it there.
What I'm suggesting is that
Oh, if you have
the jury may think it's his burden to prove great provocation or passion. It's not his burden. It's the state's burden to disprove it.
Well, it's kind of both. There has to be evidence that great provocation. I don't think it's always even an element of the crime. In other words, where it's probably an element of the crime the same time that an instruction is warranted for voluntary manslaughter. If there is no great passion, I have not always seen this in the elements of the crime. It's only where voluntary manslaughter is implicated, right? We've kind of got this fuzzy history with it.
So, let me just note in passing, the case law does not require that it be great provocation. Adequate provocation is what the element is. That's, we can talk about. But in terms of Mr. O'Hara sent me from Webster.
I'll just note, Webster, it's clearly, Webster, of course, did not do it. And part of the reason is the provocation was another person, not the decedent. And
Right.
but it also did say screaming and yelling and that sort of thing. Even with his subject, and it's not a subjective case either. He had a lot of subjective circumstances that, but it's a reasonable person standard, not a subjective experience standard. So I think this case is more than Webster, which is why we're including the instruction, but the state's noting the language in Webster is worth noting as well.
All right. So are we still talking about self-defense? You're good, of course. Why wouldn't you be?
Well, to be fair, there's a lot of instruction here on
Yeah.
a great provocation that and that reducing it to if you find unless the state has proven beyond a reasonable doubt that there's not great provocation, you can't find him guilty of second degree.
And can you point to me where you say that? Because I'm not seeing that it's the state's.
Well, I don't do it specifically, but we do
That's what I
do it in terms of that specific, but we don't do it for any of them. I'm not going to highlight it more than the other four elements.
I'm not asking you to highlight it more. I'm asking specifically that the jury be told it's the state's burden to disprove it.
If you decide the state has not proven each of the essential elements of second-degree murder, then you must consider whether Mr. Ferlazzo is guilty of one of the other lesser offenses. So that is, each of the essential elements includes the provocation element. It is an element of the charge. By putting it as an element, you have necessarily required the state to disprove it beyond a reasonable doubt. But they have to find that there's provocation, and they have to find that it's reasonable. And it was so great as to cause a reasonable person to lose self-control. Those are all the elements that are necessary for voluntary manslaughter, or else every time somebody was passionate about killing someone, it would be reduced to voluntary. Mr. Webster was very passionate at the time. He was very emotionally stressed at the time of the shooting. He wasn't, one could say he wasn't in his right mind. He was suffering from rage, which had a lot of maybe deep-seated psychological reasons. He had an expert witness testify on his behalf that he was insane at the time, I believe. But that wasn't enough to get these instructions, frankly. So we have concluded there's enough, but I think we've also provided for some, it's probably what is defined most in the elements of second degree. I think it's frankly a favorable charge to the defense.
Very.
Okay. All right. I'm up to voluntary manslaughter, page 18.
You'll see this just gives you everything you've asked for before.
So I'm up to, I finished 19, no objection to any of that. I'm on page 20.
20 I want to talk about because I want to see if there's any basis for an involuntary. I included it because you asked for it, I think, but I'm not convinced that you're really asking for it. It's pretty hard. I don't know how you get away from the intent piece, given both his interview statements and his testimony yesterday. It wasn't, there's nothing, the intent was to, I think as he described, a shooter.
I would agree to remove the involuntary manslaughter.
Okay. And you support that, is that correct, Ms. George?
Yes.
We put the presumption of innocence twice in at page 21.
What we said about it.
Take it out there. Just because that's where Peggy initially put it. I said
No,
put it.
this is different. This is about presumption of innocence with regard to degree of murder.
I'm sorry. What are we talking about?
Why are we doing it again?
I'm sorry, what are we talking about?
Was this specifically requested?
It's part of the model instruction. It was included in the defense request as well.
Okay. So get rid of, on the verdict, get rid of 5 on page 22.
Well, are we getting rid of involuntary manslaughter?
Yes.
Okay.
Oh, I can't hear anything anybody's saying. Were those comments for?
No, I was
Okay.
talking to Dana about striking certain things.
So on page 20, we are striking both the transition and the involuntary manslaughter
Yes.
instruction.
Yes. Yeah, I don't like where jury note taking is. I'm sorry, I should have told you that before this. Jury note taking should be more at the beginning of the instructions.
I didn't hear what you said, Judge.
The jury note, I meant to change that. The request was made toward the end. I don't think that's, I don't want that to be the last thing they're thinking about. I like the jury deliberations and the moderator to be the last things.
And move that up to electronic devices.
Yeah, do it with the electronic devices language. Yes.
Okay.
I assume there's no objection to moving.
No, I do have the language from a previous case on reasonable doubt, and I can send it to you. I can tell you what it says.
No, just, I mean, you're welcome to put it on the record, but send it to us.
I'll send it to you.
Judge, may I highlight one issue that just came to our attention on page 6?
Of course.
6.
That the court included language that the state has to prove beyond a reasonable doubt that the confession was voluntary.
Yeah, so
That language from something.
it is. So it starts in State versus Caron, C-A-R-O-N, 140 Vermont something or other. It is then repeated, well, it's actually, there's a PCR condition, decision authored by Justice Robinson in Sharrow, which really doesn't deal with it, but makes note of it in a different way, which seems like you don't have to do that. And then, Colts, Kolts, which is a 2018 case, maybe?
That's the one I'm looking at, which does.
Yeah, it has the language in it.
That the jury has to determine whether or not the statement was voluntary.
Beyond a reasonable doubt.
I don't see that.
You don't see it in the
Colt.
I thought that's what Judge Hort instructed, and they still didn't like it, because if that's not in there, that's the reason I continued to include it. I will say for the record, for purpose of appeal, I don't understand it that well. It's not an element of the crime,
Right,
and it's not what the court has to do. But it does cite Karen, and it cites another case, I think, in Colts.
I do see Colts, and the language that it seems to imply is that if they find that it's voluntary, then they can.
Yeah, but look at the instruction. They actually go to the beginning of the case, because they include, 20 and 21, I think. I don't have it in front of me.
I don't either.
40?
So paragraph 40 and 41, in the instruction, it states, before you may consider any alleged confession, you must find that the state has proven beyond a reasonable doubt that the confession was voluntary. And then in paragraph 41, it says, the court correctly instructed the jury on the definition of a voluntary confession. It also correctly explained the burdens of persuasion and production as to voluntariness.
It's a confusing instruction, because I could understand if all statements that were involuntary were false. There are false confession cases that, and in Mr. Colts' case, he was claiming his confession was false, that the facts he recited were not true. So that makes some sense if it's what's left. I'll tell you, it doesn't make a lot of sense to me that we have a judge saying, yeah, you can consider a jury. This goes back to what's called the Massachusetts rule. And this is a case from 40 years ago that Massachusetts came up with. And I think it was focused on what was then significant psychological tactics that were used by police. Massachusetts was a leader in addressing those kind of tactics, promises of leniency and threats of punishment sort of things that were psychologically based, the so-called Reed technique that was in vogue, and really did away with that. But with that, I think this kind of instruction occurred. We've adopted it, and the concern I have is that that is what the Supreme Court said, so I don't really think I can change it. But I don't know if they really meant it, because no one was arguing that piece of the instruction. They were arguing whether the further language that was included in Judge Hort's instruction was problematic. The defense raised that issue, and the court found it was not. But the model, the other confusing note, the model jury instruction does not include that.
No.
So that was the other issue I really struggled with, because I really question why that needs to be proven beyond a reasonable doubt.
But as the court has said, that's the case law.
That's basically where I am, which is
Right.
why I included it.
Right.
Site for Karen.
I'm sorry?
Do you want me to give this site for Karen as well?
Unless they want, they can get it from Colts.
It's not in Colts, that's the only reason.
It's okay, Dean. I mean, if there's anything you want to have a little time to see if there's anything to say, because it is confusing why 8 years later, it's still, the model jury instruction does not include that. It's more consistent with what a judge needs to do, which is, if you find it voluntary,
I'm not sure, and I'm not worried about it in this case in particular, so
Yeah.
I don't think it's worth the appellate issue.
Okay.
But it's just something to look, I'll look into it more.
yeah, I think it should be placed front and center before the Supreme Court again. I'm not willing to have it done here. I'm not saying that I would change what is the law, but I'm just scratching my head. About that. I understand needing to find that the statements attributed, that only if you consider the statements attributed to Mr. Ferlazzo together with all other evidence sufficient to prove his guilt beyond a reasonable doubt, that seems fine. It just hasn't made sense to me yet why, and I've done a lot of work on confession issues in my life. So anyway, that's where we are.
Just one final thing, Judge, on page 14, I'm wondering if it makes more sense to have your highlighted sentence where you currently have transition so that they can find him guilty of first-degree murder or they can acquit him entirely, and then you go to the second degree or the lesser included.
So the transition, the highlighted, how do you want it?
It just seems like,
So what language?
To not have it separately reflected
no, you can have it just moving that paragraph.
before
Up one.
transition?
Yeah,
Yeah.
because right now it's, you can find him guilty of murder, or you can move on to lesser included, or you can acquit him on first-degree murder.
Yeah, I think you're
or
right.
Everything.
Yeah, that seems to me, organizationally, seems to make more sense.
So
Ms. Jantz?
I'm a little confused. Are we talking about the yellow highlighted, this
Yeah,
paragraph?
just put it above,
Moving it up here.
above transition rather
Yeah,
than
yeah, yeah,
below.
that's fine.
Him before they
Yeah.
start.
Okay. Did I note there's no objection to that?
No, no objection.
All right, I'll look at that a little bit more closely and give,
What did I say? I was going to send him language on reasonable doubt and, what's the other thing?
does state want us to make a copy of Yo?
No, that's okay, Judge.
Do you want to argue anything about what I should do, or do you want me to first come out with what I think I should
I'd like
put,
to see your language
Yeah.
first.
and then we'll come back. So why don't,
So,
you can see why I thought 1 o'clock might be
Yeah.
the time we should start.
so
Okay, so we'll go back. I'm going to work on this a little bit. And
Okay.
is there anything
just-
else you wanted to address before that, Ms. Jantz?
no, just, I'm going to send you language on reasonable doubt, and I forgot the other thing I was going to
Right,
send.
and you'll send it to Ms. George.
And there was another thing I was going to send you language on, and I can't remember what it is.
I'm not going to remind you, because I don't remember.
Okay. Okay. The only thing which is not related to jury instructions is whether or not the court has made a ruling whether the state can use the term victim in their closing statement.
Are you wanting
I'm
to?
planning to, Judge.
What's that?
I'm not planning to.
That's fine. I just, because you had left that ruling open.
There's one other issue on closing that just because I want to make sure this is not an issue. I don't know if the state planned to discuss motivation for Emily being upset being the ex-wife rather than that. You can do that, but you can't make reference to the substance of the text because that was not admitted in evidence.
Yes, I think that's my plan.
Okay, perfect.
Thank you.
Anything else while we're doing that regarding closings that you think would be good to upfront discuss with the court? I don't require it at all, but if there is, I'm happy to hear it too.
No,
Okay. Any idea how long your closing might be? And
I think my first one will be about 20 to 25 minutes. It's not long. And then the second, maybe 10 to 15.
wow. Okay.
10 minutes, 15.
Okay. We will, well, then they should get just one thing. If I'm going to let them go till they want to, except I have to leave at 6 today.
So, just so I understand, we'll do our closings, you'll read instructions, or you'll put that off to tomorrow?
No, and not if you're taking an hour for closings. We'll go right into the instructions and let them get the case.
Okay, that's
Yeah. Yeah, I expected they might have been, you can play it both ways, but I expected they might be a lot longer than
Yeah.
indicated.
Yeah,
So
yeah.
that's helpful to know. Okay? Thank you. All right, tell me when we're on. Back on the record in State versus Ferlazzo after considerable break for the court to mull over some of the issues. I think the court's most concerned about the rather confusing language that exists as to relating to, on a first-degree murder case, how to do it, what deal with the issues of great provocation or sudden passion. And what the court balanced on, again, Yo makes reference to it. Yo also did not include instructions that addressed great provocation at all or sudden passion. Indeed, they weren't, the jury instructions were not a specific basis, but there are those paragraphs in Yo that make it clear that the finding of first-degree murder necessarily finds that there was not great provocation or sudden passion without those terms necessarily being defined. It seems, though, after Lasky, the better practice is at least to reference that a finding beyond a reasonable doubt of deliberation and premeditation necessarily precludes a finding of great provocation and/or sudden passion, and I then say those terms are defined further in the instructions. So I thought that was a good way to balance the fact that deliberation and premeditation are already defined in much greater detail now than they were by the court in Yo, as to make it clear to the jury that it can't do that. But given the language of Belaski, I think reference to those concepts are required there unless the Supreme Court suggests otherwise, and can be defined once in the instructions, or twice, actually. I think they're defined, but don't have to be defined there. So that's how I did that. In terms of the reasonable doubt, I wanted to get the state's view of those two. One is simply saying probably guilty rather than probably true, which is what the model has. This was just Cooper Smith using the term probably guilty rather than probably true.
Yeah, so I think from the state's perspective, we think that the model jury instructions and the language there of probably true is the language the court should use.
Yeah.
I haven't seen the other language.
Yeah, it was a judge. You know, Judge Cooper Smith used to add things. He used the term substantial certainty. They didn't like that. Then he used great certainty.
Did use both, and in more than one murder case.
Yeah.
And I think...
And the Supreme Court kind of threw it back at him and said, don't get too creative with reasonable doubt.
No, but I don't think...
They didn't reverse him, but they did say that.
I don't think it's creative for it to be explicitly stated that even if you think the defendant is probably guilty, I think that needs to be said. I don't understand.
It doesn't have to. It's a difference without a distinction without a significant difference.
I don't agree, but...
All right. I'll note your objection.
Thank you. And what about the other part? I think it's important for them to know that they don't all have to have the same doubt, and that they don't have to be able to articulate it. That, you know, there may be pressure for people to say, so what's your doubt? What is it based on? And if they just say, I can't explain it, they need to know that that's sufficient. They don't have to be able to explain it.
I'll hear from the state first as to whether it has any objection to it.
The state does have an objection to it. I think when when we start the instruction by saying we don't have a definition, we're not going to try to define it, and then we spend all of this time trying to define it and trying to tell the jurors how they are supposed to feel about it, it provides conflicting information. I think there's a reason that we have the model instructions. It's because those are the instructions that through over time and through Supreme Court case law has said these are the instructions that are safe, that are accepted, and then when we start adding in all of this additional language, I think we run the risk of having somebody say, this was inappropriate language, we should not have told the jury those things.
So model jury instructions are just that, a model. They're not set in stone.
Yeah, apparently not, because the one for voluntariness is not what the Supreme Court said it has to be.
That's right.
Yeah,
And
so far.
I do think it is important to let them know that they don't have to be able to explain their reasonable doubt, and that it doesn't have to be the same as everyone else's. I think.
Yeah, I appreciate the effort. I'm not going to change the instruction. I think it's what it is, and it's made more confusing by the fact that we're using a reasonable doubt standard, also of a voluntariness of confession. It's
Judge, I don't think those two, I think that's apples and oranges.
It may be, but I'm afraid of it being confusing. And this is the standard instruction. I think it's a fair instruction, so we'll include it as is.
And note my objection.
I appreciate it. Thank you.
And so am I to understand you're going to give us language about the provocation and passion, or you already have?
I did it. I made it one sentence. I played with it back and forth. It's really either putting the entire definition here and then not repeating it down the road. But I think the definitions, first of all, it's never been included that I know in a first-degree murder instruction. So I am concerned by that, and I think that's because the definitions of premeditation and deliberation are considered sufficient. I do think, given the language in Yo that says they necessarily did not find great provocation or sudden passion in finding him guilty of first-degree murder, suggests that I should at least reference that it's a finding of premeditation and deliberation is inconsistent with the finding of great provocation. I do refer the jury to the definition of those terms under second degree.
So, to be clear, on page 12, second paragraph, that's out, highlighted in yellow. This is the language the court intends to include.
Yeah, you obviously, I'll start with the state. Does the state object to this language?
No, the state does not object to that language.
All right. And I was waiting.
Checking with my
I was
appellate
waiting for
counsel.
Mr. Harrah's appearance.
Yes, yes. So it's not as clear as I would like it to be. As the court saw, I asked for a specific instruction that contained the 4 elements and that the state bears the burden. So I'm going to object to it.
I appreciate it. As the Supreme Court has repeatedly stated, and as the instructions state, the instructions are to be read as a whole. The definitions of the terms are thoroughly discussed at various parts after this that can be reconnected with this. On the other hand, given the confusion of Yo, I thought this was a good balancing way to deal with this. So we will include this instruction. I did change, and I guess the only other thing is neither party asked for this self-defense and lesser included thing. We just added it. I don't
Where is the court?
I'm on page 14. You know, there was a request to move it above the transition language. It can go. It didn't really matter which way it went. There are reasons which we argued about why it should go either below or above. But frankly, it's also not necessary if the parties don't want it, since we're the ones who added that language.
So are we talking about the sequence? Is that what you're talking about?
Sequence, or whether to include that first paragraph at all.
The one starting, if you conclude, is that?
I'm sorry, I'm gonna.
Yes.
If you conclude, yeah,
Yeah.
I think that whole sentence, neither of you asked for, I
No, I like it.
thought you might, having seen it. All right, then we'll leave it as that. We didn't put it above the transition language. I'm trying to see, is there anything else? Well, you folks are obviously just getting this, so I should let you have a little time to go over it. But I think every other change I think we put in, we had discussed before.
Okay, so my objections are noted on reasonable doubt and passion provocation.
There.
Thank you.
While we're here, did you have any further motions to bring?
No.
Okay. All right. We have 5 minutes. Let me sit here while you guys at least have some time to review the charge again. Of course, if over lunch you look at it and you say, we really should have addressed this, we're going to address it again before it's finally read to the jury. It is my practice to make a copy of the charge for every juror so they have it. I don't do the 3-copy thing. I like to give everybody their own copy.
Yeah, I think so. And if it helps, we can print our own. We don't need the court to print copies.
I do. I need a copy.
And we are happy to provide you one, Ms.
Thank you.
Jentz.
I appreciate it.
Judge, is the court taking out the word transition, or do you leave those in? I'm just curious.
You don't need it.
We don't need it.
We don't need the word.
Nope.
Okay.
All right. You saw we put note taking after electronic devices.
Yes.
And you might want to look at how the phrasing of exhibits that put in there. I don't think there's anything too controversial about it, but
I have no objection to that language, Judge. With respect, this is on page 7, second paragraph under exhibits. And this is with respect to the bullets and the video and audio recordings. I have no objection to that language.
Ms. Adams.
I think it might be a little confusing because there are
Played or
bullet.
viewed for you, number one. And the last, because we're not going to play the
Right.
PowerPoint, so played or viewed for you, but yeah, that's probably not what you were bringing up.
That's not what I was going to address. I think the bullet exhibits is a little confusing because we had multiple bullet fragments. They are going to have those. I think what they're not going to have is the magazine and the
So
unfired.
the magazine and
Ammunition.
bullet, the ammunition exhibit. Why don't we change bullet to ammunition? Does that do it? Magazine, ammunition and
Yeah, I think we
and
could say
magazine.
the magazine and live ammunition will not be, and the video
Yeah.
and audio recordings.
That's fine.
That seems, okay, and they're not played or viewed. We'll add played or viewed, and we'll add the language the state just requested. And it should be exhibit, not exhibits, under bullet, after magazine and live. It's only one exhibit, right? The magazine
Yes.
and the
That's right.
live ammunition is.
And I don't know if it's, oh, I guess the court has purposely formatted it that way. The bottom of page 9, the paragraph is just very narrow, but I think the court intended to format it that way.
The margins are centered rather than full page,
Yeah, that was just the charge.
but it's just that one paragraph at the end of page 9.
Right, because that's
And
what
so that was the
it's
intent.
stated as the
Gotcha.
charge, and
That's fine.
just did that.
Can we have 2 physical copies, one for me and one for Ms. Johnson?
Please.
Thank you.
She's allowed to look at it.
Because we're all copies.
What?
I normally would also be a copy.
Yeah, if Mr. Ferlazzo wants a separate copy, he can have it.
You can have a copy as well. Okay, thank you.
Okay. Folks still looking at things, or we're okay till 1?
Okay.
I don't know what you're saying.
Do they want a verdict form?
No, we'll get them a verdict form beforehand. They're not overly complicated. Certainly let them change it if they think they need to.
We can do that.
Do that again. Anything else before lunch?
No, thank you, Judge.
Okay, see you all at 1. set. We're here in the matter of State versus Joseph Ferlazzo Jr. After a lunch break, in 21 CR 8967, Mr. Ferlazzo is here with his attorneys, Ms. Jantz and Ms. Johnson, in the state, Ms. George and Ms. Adams. I have sent what I consider the final version. I haven't looked at your email. Did you have any problems, Ms. Adams, with the jury form?
Not with the
I
verdict
saw
form.
that you
Nope.
sent it. Does the defense have any issues with the jury verdict form?
I just saw it, Judge.
All right, I'll go forward. I'm not going to deal with that now.
That's fine. We can
I don't
talk about
think
that.
you're likely to, so if you do, I don't think it'll take very long.
Yep.
Are the parties ready to proceed with closing arguments?
Yes, Judge.
Yes.
Okay. Let's bring in the jury.
She wants to stay here. All mangled. But I care about it. I was like, I'm just going to stay for like 3 months. Something really so good. Oh, okay. So, do you want to care?
Please be seated. Good afternoon, everyone. I'll note the presence of all 16 members of the jury, and I'll ask my usual questions. Has anyone learned anything about this case outside of the courtroom since we adjourned yesterday from the proceedings? I am seeing, I think, 16 shakes of the head no. Did anybody read any accounts of this or discuss this case with anybody else since leaving the courtroom yesterday? Again, seeing shakes of the head no from all 16 members of the jury. It is now time for closing arguments. We'll start with the state. Ms. George.
Thank you, Judge. Good afternoon. In October of 2021, Mr. Ferlazzo and his wife, Emily, made a plan to come to Vermont for a weekend for their 1-year anniversary. You heard from Emily's mother that Emily was excited. She was looking forward to meeting her sister-in-law, Nicole. She was in a good mood, and she was looking forward to the trip. They drove up here in their van with their dog from New Hampshire on the evening of Friday, October 15th of 2021. They arrived in Vermont at the Bear Run condos at 7:20 p.m. They parked at a condo complex on Bear Run in Bolton. They met with Nicole for about 15 minutes out in the parking lot inside the van with a plan for Mr. Ferlazzo and Emily to meet them inside the Airbnb to catch up, watch Netflix, and hang out. But they never did. And we know that Emily sent her last Facebook message to her family at 8:13 p.m. We know that Mr. Ferlazzo sent a text message to his sister Nicole inside the Airbnb at 9:39 p.m. Hey, we're gonna take the night to rest, smiley face. You still drink coffee? We'll see you tomorrow morning. Shortly after, Emily's last location data from her Facebook is logged as 10:14 p.m. Instead of going inside and spending time with his sister, Mr. Ferlazzo and Emily argued. They argued because Mr. Ferlazzo had brought Emily on their 1-year anniversary to the very same condo complex that his ex-wife lived. They argued because Mr. Ferlazzo seemed to believe that he didn't have any obligations to be monogamous with his wife, be faithful to her, and she told him she was done. She told him she did not want to be with him, that she could not do it anymore, and that she wanted to leave. And 1 minute after midnight, Mr. Ferlazzo turns off his phone. Done arguing, Emily laid down in bed while Mr. Ferlazzo stayed up and stewed. He became enraged at Emily while she lay in bed scrolling on her phone with her head on her pillow. Mr. Ferlazzo sat on the couch thinking, planning. For what he told police was 5 to 10 minutes. For at least 5 minutes, Mr. Ferlazzo sits on the couch and stews. By this time, Mr. Ferlazzo has a plan. He's made a decision. He has decided that he needs to stop her, that she is not leaving him.
I don't even know. I just know that I sat down and was. I don't know, something inside my head, just I remember feeling really warm, and I remember feeling blurry, and I don't know. Something inside me said enough is enough.
Something inside of him said, enough is enough. But instead of walking away from Emily, going into his sister's Airbnb, out of the van, instead he executes his plan. He got up from the couch, he went to the closet, he grabbed this Glock 19 with this silencer. He walked over to the bed. Emily's head was resting on this pillow. He picked up this throw pillow from the couch. He jumped onto the bed. He put this throw pillow over her face, and he shot her once and twice, directly into the left side of her head, killing her. Both of those bullets exited her skull on the right side of her head and came to rest inside the very pillow that her head was laying on.
When you jumped on her, did she say anything to you?
Something are you fucking kidding me? You gotta be fucking kidding me.
And then, what was her reaction to you?
It was just like that. Okay. I just jumped on her. She said, are you kidding me? Something like that.
Did she try to fight you or anything like that? And how long did you have to wait? Was it between when you jumped on her and when you fired the first shot? And how about the second shot? So I don't want to put words in your mouth or anything. I'm just trying to understand. So he essentially, correct me if I'm wrong, you jumped on her and bang bang like that. Is that how it happened?
And I think you shook your head no, but when Seth asked you if she tried to put up a fight, did you say yes or no? There was no fight? Okay.
The evidence presented in this trial shows that Emily posed no threat to Mr. Ferlazzo. And in fact, his story that she had a gun was directly contradicted by the fact that both of the pistols were his. Emily did not have a gun. His story that he remembers Emily's body falling after he killed her is directly contradicted by the physical and forensic evidence. Dr. Shapiro told you that her head was resting on something when she was killed. And immediately after killing her, rather than calling 911, any police agency, his ex-wife, or his sister, who was just yards away from him, Mr. Ferlazzo instead shuts off Emily's phone because, in his words, quote, he wasn't going to use it and she wasn't going to use it. After he shut off her phone, Mr. Ferlazzo puts a market basket shopping bag over Emily's head, tied a garbage bag around her neck, used his 6-foot, 200-pound body to carry her 5'1", 130-pound body into the shower. He bagged up this bloody pillow. He bagged up this red throw pillow. He bagged up this bloody pillowcase, this bloody sheet. He then put her shoes, her glasses, her wallet, and her phone in a plastic grocery bag, but was careful to keep her ID. He put new sheets, a new blanket, and new pillows on the bed, and he turns his phone back on at 1:35 a.m. Then he turns it off at 2:10 and back on at 3:39 a.m. Then he gets back in the very bed he just killed his wife in. And just a few hours later at 7:48 a.m., while his wife's body is in his shower, he texts his sister, "I can't sleep. Any interest in going for breakfast?" And even makes a recommendation on where to go. "Maxie's has really good breakfast, exclamation point. I just French pressed some coffee. Have you had coffee yet?" And off they go to Maxie's, where Mr. Ferlazzo has eggs and a mimosa. Then he drives his van from Bolton to St. Albans, parks the van on the property of his best friend. And rather than telling them that Emily's in the van, that he killed her, that he had to kill her, he tells them she took off. And then he sets up shop and starts to give his sister a tattoo. But not before sending Emily's phone a text message. "Whatever, exclamation point and angry face. I'm gonna spend time with Nikki while I can, exclamation point. Call me." And 3 hours later, he finishes his sister's tattoo. And an hour after that, he goes out to eat again, this time at Twig's, a gastropub in St. Albans. He eats dinner, he has drinks, and he gets a ride back to the Lang residence, and he again sleeps in the van with Emily's body still in the shower. And the next day, he goes out to Burlington with his sister, he gets coffee, and again, he goes out to eat. And again, he says nothing to Nicole about what he did to Emily. And after gallivanting around downtown, he heads back to St. Albans, and on his way, he stops at Hannaford to buy bleach. Because despite him continuing with his life as if nothing has happened, he does have a mess to clean up. That night, he hangs out with friends around a campfire. 2 of his best friends and an off-duty police officer. He engages in small talk. Doesn't mention Emily once. Doesn't even mention that he has a wife, as if she just doesn't exist. You heard testimony that the campfire wraps up around midnight when Mr. Ferlazzo gets back into the van, and while Emily's body lays feet away from him, he sends her phone another text message. The same phone that he turned off after killing her because she wasn't going to need it, and the same phone he threw away somewhere between Bolton and St. Albans. "This is far enough, exclamation point, exclamation point. Get your ass home, exclamation point. I gotta go back to New Hampshire, are you coming back?" And amongst all of these activities, he decides that he needs to make her body easier to carry, easier to move, and easier to discard. Mr. Ferlazzo uses this serrated saw and dismembers her arms, her legs, her feet, and her head. He dismembers them from her torso. The same torso, absolutely riddled with stab wounds, including one striking her heart. 3 different knives had her DNA on them. At least 3 different knives were used to stab her heart 1 time, her abdomen 8 times, and her back 9 times. Then he puts each piece of her body in garbage bags. And on Monday morning, before leaving for New Hampshire to get his Jeep, which he told you he needed in order to bury Emily's body in the woods, he just can't help himself. Knowing full well exactly where she is and what he has done to her, he texts her phone one last time. "You're an asshole. I don't deserve this shit. You're an asshole. I don't deserve this shit." Ms. Adams told you in the state's opening statement that this case and this crime is about ego, Mr. Ferlazzo's ego, and Mr. Ferlazzo's nearly 42-year-old ego being unable to accept his 22-year-old wife disrespecting him. That ego believed it was his right to cheat on Emily, to have relationships with other women, whether she liked it or not. That same ego believed it was his right to follow Emily one day when she wore her hair a different way and he didn't think she was being truthful to him. That ego was so inflated that even after shooting his wife in the head 2 times, stabbing and dismembering her body, bagging her up, and discarding her like trash, he didn't tell his sister because he didn't want to make a bad impression with her boyfriend. So inflated that he didn't tell his sister because he'd promised not to, quote, dump his drama on her. He considered killing his wife drama. An ego so inflated that after killing her, taking her life because he didn't like the things she was saying to him, because she didn't want to be with him anymore, he calls her an asshole. He tells her that he doesn't deserve this. The state submits that it is Emily, and only Emily, that did not deserve this. All of the credible evidence presented by the state during this trial, the witness statements, the physical evidence, the forensic evidence, was checked and verified. The details of her death, the details of the weekend of the dismemberment, the trip back to New Hampshire was all corroborated, checked, verified, proven beyond a reasonable doubt. We are confident that you will find that Mr. Ferlazzo killed Emily and that that killing was unlawful. There was no legal justification for it. It was willful. It was intentional, it was deliberate, and it was premeditated. And the state requests that you find him guilty of first-degree murder.
Ms. Jantz.
Thank you, Judge. I do plan to move this probate because this is in my way. Don't need it. What I say to you now and what Attorney George just said to you is not evidence. We're just giving you our spin on what we hope that you will conclude after your deliberations. It's up to you and only you to decide what the evidence shows. Not what I say, not what she said. You are the finders of fact, not us. There's been some conflicting evidence in this case. some undisputed evidence. You've seen the video of what Mr. Ferlazzo Joseph told the police on the day he was arrested and detained. You know that in that video, and as he told you yesterday, he hadn't slept for multiple days, he hadn't eaten. He says multiple times, my mind is scrambled, I'm not thinking clearly. But there is a roughly 2.5 hour recorded statement of what he tells the police happened. One of your jobs is going to be to decide if that was the whole story. If he was able, because of lack of sleep, the events that had transpired over the weekend prevented him from being clear and rational. You heard him tell you yesterday he has no memory whatsoever of that interview. None. He said it was like watching himself if he'd been at a party and been blackout drunk. He's seen that video, I think, 3 times now. He told you yesterday that he was revolted by his apparent detachment in describing the events of what happened over that weekend. And you saw him on multiple occasions express emotion in talking and thinking and remembering what happened. The detachment that he described, his demeanor, is part of his habitual. He said he was a closed person, very private, didn't like to express his feelings. And it's something he learned from childhood, something he learned in the course of his work as a tattoo artist, how to compartmentalize feelings, emotions. He told you as a tattoo artist he'd learned that because it hurts, you make small talk with people and distract them from the pain that they're experiencing. This is just a habit for him. It comes across, as he described, as revolting detachment, but it's his way of coping. What he told you yesterday is not what he told the police. He explained to you that his memory of what happened ended at some point that weekend. He remembers the events now. He remembers the events leading up to him shooting Emily. He remembers some of the events of Saturday, what he did. He doesn't remember much, if anything, of Sunday, Monday, Tuesday. He told you that after he had had an opportunity to sleep for a couple of days, he came to and he started having nightmares and remembering things, bits and pieces. And even as he talked to you yesterday, he said his memory is fragmented, very fragmented. And he is struggling to understand what happened and why. What he told you yesterday is that over the course of their relationship, Emily had become physically abusive to him. The reasons the state would have you believe is that the state would have you believe that he's an egomaniac. It's up to you to decide if you saw any evidence of that in his demeanor or his testimony yesterday, that he shot her because she disrespected him. He told you clearly about how many times she had hit him with objects, with a cell phone, with her fists, with a laptop, with a wine bottle, gave him a black eye once, and he never hit her back. He said, I would take her arms and restrain her. Until she calmed down and say, we don't hit, we don't hit. They even went to a counselor together to address issues in their relationship. He said, I grew up with domestic violence and I didn't want to bring a child into a relationship like that. That was his experience of interacting with Emily when she became frustrated and acted out physically against him. He told you that that weekend they were coming up here to see his sister and to celebrate their anniversary. They got here, they were both happy to be coming, both excited, and on a dime, she flipped. I don't want to be here. F you, F your family. I'm done. He's not denying that he sent texts to his sister. He's not denying much of what the state's evidence shows. He knows that and told you, yeah, I lied. I lied because I didn't want to I didn't want to tell my sister because you may or may not agree with his explanation. She didn't want his drama in her life. You heard the state say killing his wife was drama. Well, you have to put yourself in his shoes and his thinking. But in any case, that was his explanation for why he didn't tell Nikki about what he had done, that is, shooting his wife in the head. So that weekend they come up, they get into an argument. He told you clearly that she had been muttering and angry, and when he put on the candles, she was angry about that, and she picked up one of the candles and started hitting him. Hit him in the head, hit him in the arms, hit him in the torso, kicked him in the groin. He was able to stop that attack. He took the candle away from her, and then he took their dog out, Remy. It was raining. They went out for a walk. He had also told you earlier that he thought he saw coyotes and was afraid potentially about bears. And that's why he told her, get your Taurus and keep your peace with you. And he kept his Glock with him. There's no dispute that the guns were his. That doesn't mean she didn't use it. He said, she preferred the Taurus because the barrel was shorter, or the handle. He used the Glock. That was hers, that was his. Legal ownership is not the issue. So they both had access to their guns that night. He comes back in from walking the dog. She's on the bed, scrolling through her phone, muttering, and he pours himself a drink, one of many that he had that night, many. Vodka and Red Bull. At some point, so he dries the dog off, dries himself off, and at some point decides, okay, now I'm going to get into bed. In order to do that, he has to climb across Emily. Emily says something, fuck you, something like that. He picks up the red pillow, which was right on the little couch they had next to the bed, and this pillow, swats her in the head with it. She turns to him and says, that's it, you're dead. That's it, you're dead. She elbows him in the groin. I had that backwards. First she elbowed him in the groin. Then he picked up the pillow and swatted her. Then he saw, and she said, that's it, you're dead. He saw her start to pick up the gun and shoot him. And you heard him tell you, I was terrified. I knew she was going to shoot me. That was his belief based on circumstances of that evening, what she said to him, the history of their relationship. He truly believed that she was going to shoot him and that he had to shoot her with the Glock that was already in his hand in order to save his own life. That's what he told you yesterday. It's not what he told the police, but that's what he now remembers happening. He also told you, I felt a wave. This he did tell the police. I felt a wave come over me. I was hot. I couldn't take it anymore. I felt blurry, loss of focus. All of that contributed to his decision and was a decision to shoot her. Then what? Then what happens? Well, he has some memory of sitting beside her body. He's told you a couple of times, I was talking to her at various points over the next couple of days. This is a man who was somewhat, if not heavily intoxicated, also smoking marijuana, just experienced a trauma, and is grasping, what do I do now? What do I do? When he talked to you about this, you saw him break down and become emotional and cry. This is not someone who is a cold-blooded murderer. He cared about his wife. You heard him describe their early relationship as euphoric and magnetic. He was in love with her. He kept telling her, this is not how we treat each other. You don't hit people. But on this night, he truly believed that she was going to shoot him. And that's why he shot her. So over the course of the rest of that night and into Saturday, he made attempts to prevent anyone knowing what had happened to Emily. He doesn't deny sending some of those texts. Some of them he doesn't remember. Some of them he does. And he told you, I lied. I know I lied from what he can remember. He was intending to try and go back to Pennsylvania to help his grandmother. You can decide whether or not you think that was a good enough reason for what he did, but that was how he was thinking at the time. He also said, I wanted to give her a burial. He has no recollection of stabbing her. None. None. The medical examiner told you there's no way of knowing when those injuries were inflicted, except that they were not immediately following death. Similarly, the dismemberment. They also were not immediately following her death. This is not an easy case because on the one hand you have verifiable evidence of what happened, but what you don't have is the why. Mr. Ferlazzo gave you the why yesterday. He explained why he did what he did. Your biggest job is going to be to decide, is he lying now just to get away with it? Is what he told the police in that interview the whole truth? He told you he has only partial memory of the events that followed, and he admits, I shot her. He knows, he's admitting that. That's not what this case is about. This case is about why did he shoot her. Ego, or someone who had been pushed to the point where they could no longer tolerate being hit. And I know, he's big and a man, 20 years older. She was a little girl. You heard him tell you that she hit him and hurt him each time. She hit him with a bottle, hit him in the head with a wine bottle, hit him in the head with a big Yankee candle. That hurts. You can do that however small, or the discrepancy in your size. And he didn't hit her back. Not once. The judge is going to instruct you on the rules of the law in this case, and it's not my job to do that. Your job is to assess what you heard him say yesterday, how he appeared, what you think about whether he's lying or not. That's your job. I don't envy you because I think it's a hard job, but that's what you will be asked to do. What do you believe is the truth? What he told you yesterday or what he said to the police? I think that you will find him not guilty of first-degree murder and acquit him on the grounds of self-defense. Thank you.
Ms. George, do you have a final summation?
Mr. Ferlazzo claims that he doesn't remember what he told police, that he doesn't remember being in the interview with police, and that he doesn't remember much of the night he killed her, and that his memories were not full at the time and are still fragmented. Luckily for Mr. Ferlazzo and for all of us, every single word that Mr. Ferlazzo said to the police about what happened to Emily was recorded. The reason that Trooper Cody turned on his body camera when he called Mr. Ferlazzo. The reason that Detective Voris did the interview in a room equipped with video and audio. The reason that Detective Voris made sure to have an extra recorder on his body when he went into different places, went to the breaks, went to the holding cell, just in case. The reason was all to make sure that everything Mr. Ferlazzo said about what happened to Emily was recorded, and that we would all be able to refresh his memory. You all heard every word that he said to the police, just days after he killed Emily. We played you every video, every recording. You have the transcripts. There are no secrets here about what was said or done. There are no mysteries. And immediately after signing the Miranda warning with Detective Voris, Joseph was ready to talk.
All right. So Joe, is it fair to say that you have an idea of what we want to talk about?
Yeah.
All right.
I'm here to talk to you. Like, you don't have to beat around the bush.
Okay.
I'm sure you already talked to Spencer. I fucked up. Like I said, like, I had a fucking lapse. And did something that I can't undo. So here we are.
And less than 2 minutes after that,
So I came to Vermont. I was living in New Hampshire for like the last 2 months with my wife and her family. And I came to Vermont. We were supposed to have like a weekend away, like vacation, do some camping, like have some fun. And like as soon as I like put the vehicle in park, like my wife went completely berserk, like completely psychotic. And I shot her as a result of that. And now here we are. So,
All right. Can you, where did that happen?
Bolton, Vermont.
When did that happen? Saturday. Do you know about what time? Saturday evening? Alright.
No, wait. No. Saturday morning. I think I was thinking it was like, yeah, it was Saturday morning.
The state believes that the interview, the recordings, and the transcripts of the same all show that Mr. Ferlazzo was ready, he was willing, and he was able to give a coherent, a voluntary statement. You saw for yourself how he interacted with police throughout this interview, and you saw for yourself how he presented on the stand. You heard him outline in the interview with police in great detail what led up to shooting Emily twice in the head, and never, not once, did he say that Emily was a threat to him, that she had a gun, that he thought she was going to kill him. In fact, what you heard him say repeatedly when asked multiple times was that she had stopped fighting.
Can you describe Emily when you shot her? Like, what was she doing?
She had stopped fighting and she had gone and laid down. And I went and jumped on top of her. And I shot her in the head.
How many times?
She had stopped fighting, she had gone and laid down. I went and jumped on her, and I shot her in the head. The physical and forensic evidence shows that Mr. Ferlazzo did not act in self-defense. Just days later, he had no injuries, no bumps, no lumps, no bruises, no scratches, no burn marks from this alleged burning candle that was wrestled over during this interaction that he testified to yesterday. The physical and forensic evidence shows that this was willful, that he intended to do it. His actions were deliberate. They were not provoked under any circumstances, and they were premeditated. He planned to kill her during that 5 minutes, and he executed that plan. Mr. Ferlazzo's statement to police is detailed, it's thoughtful, it's thorough. At times you see him correct himself if he gets a detail wrong. He goes out of his way to correct it with police. He's given opportunities to warm up, to sleep, to eat, to drink, to smoke. He was given numerous breaks. He had time to contemplate and correct inaccuracies, fill in the details when police asked for them.
And while this was the policy that was watching in that, where were you when it
He's sitting right here on this little couch. The right couch on that.
Sure. And I think we had asked where the Glock was currently, but where did you get it from?
It was in the closet.
Where's the closet?
This is the closet.
Okay.
I was on the couch.
Okay.
I just like got up and grabbed it and shot her.
At no point during his statement does he ever say anything about Emily being a threat to him. At numerous points you heard him talk about the feeling that he had before he did it, that he felt warm, and he specifically described that feeling as rage, how he wanted to stop her, and how he made a decision to do that.
I remember sitting there
talked about before, like you felt like a warm sensation in your body?
I think it's loss of focus, rage, heat.
Were you feeling angry, or were you feeling sad, or how were you feeling?
Felt pushed, fed up.
Pushed and fed up. In defense counsel's arguments, they said that it will be up to you to determine whether or not Mr. Ferlazzo on the stand yesterday was telling the truth or if he was lying to get away with it. Making up a story now to get away with it. That will be up for you to decide. But the state would just highlight that Mr. Ferlazzo testified to a history of abuse, being assaulted by Emily numerous times, having black eyes, bumps, bruises. But not a single witness got on the stand during this trial and corroborated any of that. No friends that they lived with or hung out with saw any of this alleged abuse. Nobody saw these bruises. The only witness that got on the stand and testified to seeing bruises was Adrienne Bass, Emily's mother, who testified that Emily had bruises on her, who said that Joseph was taunting Emily while they were driving once, so much so, and poking at her so much so that Adrienne feared for their safety. Adrienne told you that at that New Year's Eve event, Emily called her on the phone and she had locked herself in a bathroom, and Adrienne could hear Mr. Ferlazzo yelling at her on the other side. That's the evidence that you heard. Further, again, Mr. Ferlazzo testified that Emily had a gun, a detail never mentioned until this trial. The detail that Mr. Ferlazzo now says he left out of his interview with police, the reason, the why he killed Emily, arguably the most important detail for a self-defense claim, the most important detail that most people would have led with, is now the detail that he wants you to believe over everything else. He wants you to believe that detail so much that you acquit him of this crime. But not so important that he didn't tell his sister, he didn't tell his best friend, he didn't tell the police. Specifically, he didn't tell Trooper Cody, he didn't tell Detective Voris, he didn't tell Detective Richardson, he didn't tell Detective Truex, he didn't tell Detective Nolan. A detail so important that he only knows this detail exists because it came to him in flashbacks. This is not a flashback. This is not a merry-go-round. This is reality. And in reality, there is not a single piece of evidence to corroborate this one detail. The truth in this case is not complicated. The truth is simple. I fucked up. I made a mess. I cleaned it up. We believe that the evidence shows beyond a reasonable doubt that Mr. Ferlazzo killed Emily and that he did so willfully, that he did so intentionally, that he did not do so in self-defense, that it was deliberate and it was premeditated. And we ask that you find him guilty of first-degree murder.
Judge, may we approach, please?
need a break, or are we ready to hand out?
No, because I had sent the court something,
Why don't we have one last detail to deal with, then we'll bring it in quickly and go into the closing jury instructions, and then you'll get the case. Okay, but we'll take a quick break.
All right.
The pages have changed.
I see that. So, and it would be a lot easier if I had the hard copy, or if I could look at a hard copy.
We have 21 of them, are on there.
You can sit down.
Oh, please, everyone sit down.
Just hold them that.
Whatever you want.
Okay, now I know where are you ready?
What page?
12, first paragraph.
Well, huh.
So, as it now reads, to find Mr. Ferlazzo guilty of first-degree murder, you must find beyond a reasonable doubt the killing was not done under great provocation or sudden passion that would cause a reasonable person to lose self-control and act without thinking, as further defined in the remainder of the charge.
Right, we already dealt with that, I thought.
Okay, no, I think that's fine.
Okay.
Okay. I still am asking, I did object.
Yeah, you've got,
Okay.
I mean, unless you want to repeat it.
No.
You objected that you wanted the full
Well,
thing that's repeated under second degree, repeated under first, I think is what you said.
so I do object for the reasons stated, and I also object to the language of reasonable doubt.
Okay, yeah. Great. Are we ready for the jury? Can't promise to move.
Oh, I thought we were taking a break, because he's not here.
Oh, he's not here. Okay, we're not ready.
Yeah.
Yeah, you can do that. That would be great.
I agree, but
So
it's,
why don't we do this? I won't send in initially. I'd rather get the jury started.
Fine.
And we'll get them, but I'm not inclined to put anything about passion or any of that. They've had those instructions. Each one is getting, there's a copy of the instructions. They're taking them with them to the jury room. They'll have the definitions in there.
I just thought it was confusing because it's inconsistent with the instructions.
I don't think it's inconsistent.
Well,
I think it just doesn't repeat the instructions.
Well, because your instructions on page 12 indicate that in order to find the guilty, you must find the killing is not done under greater provocation, etc. And that's not in the verdict form.
Why don't you bring in the jury? My water. Great. Please be seated. Ladies and gentlemen, it's now time that I read jury instructions to you. You'll note that each of you has a copy of the jury instructions. You're free to read along with me. I'll be saying them out loud, so if you prefer just to listen, you can do that. But if it's helpful to read along, that's fine too. You'll be able to take a copy of these instructions into the jury room with you when you begin your deliberations. Members of the jury, now that you've heard the evidence and the arguments, I must instruct you on the law that applies to this case. You must follow the laws stated in these instructions. You must determine the facts based on the evidence that is presented in the case, and you must apply the law that I give you in these instructions. You must not single out any one instruction as stating the law. You must consider the instructions as a whole. You should not concern yourself with the wisdom of any rule of law or any opinion you might have about what the law should be. You may not base your verdict on bias, prejudice, or sympathy. Do not consider consequences. In your deliberations, you are not to consider what happens after your verdict. Under Vermont law, all matters after the verdict are solely the responsibility of the court. The charge. The state has charged Joseph Ferlazzo with first-degree murder of Emily Ferlazzo as follows. That Joseph Ferlazzo in the county of Chittenden at Bolton on or about October 16, 2021, willfully, deliberately, with premeditation with intent to kill, unlawfully killed a person, to wit, Emily Ferlazzo, by shooting her twice in the head. Mr. Ferlazzo has pleaded not guilty to the charge. On or about. You will note that the charge alleges that the offense was committed on or about October 16, 2021. The proof need not establish with certainty the exact date of the alleged offense. It is sufficient the evidence in the case proves beyond a reasonable doubt that the offense was committed within the period of the date alleged. The charge is not evidence. The fact that Mr. Ferlazzo is on trial is not evidence against him. Likewise, the charge that the state has filed is not evidence of Mr. Ferlazzo's guilt. You are not to be influenced by the fact that the state has brought this charge against him. The burden is on the state to prove that Mr. Ferlazzo is guilty. Presumption of innocence. Mr. Ferlazzo is presumed to be innocent of the charge. This is called the presumption of innocence. Although Mr. Ferlazzo is accused, he is innocent at the beginning of the trial. This presumption of innocence stays with him throughout the trial and during your deliberations. The presumption is itself a piece of evidence which you should consider in Mr. Ferlazzo's favor in deciding whether to find him guilty or not guilty. The presumption of innocence means that you must find Mr. Ferlazzo not guilty unless, after careful and impartial consideration of all the evidence, you are satisfied beyond a reasonable doubt that he is guilty. Evidence. Your duty is to determine the facts from the evidence. The evidence is the oral testimony of the witnesses and the exhibits which have been introduced into evidence. Any testimony which I have stricken from the record or excluded from the case is not evidence, and the comments and arguments of the attorneys are not evidence. Furthermore, I do not intend to indicate one way or another as to how you should decide this case based on my rulings I have made or anything I have said. The attorneys have a duty to object to questions or answers which they believe are not admissible. You may not hold it against either side if an attorney feels it is necessary to make objections. Circumstantial evidence. There are two types of evidence from which you may find the facts of this case: direct and circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances which may tend to prove or disprove an issue in the case. For example, if a witness were to tell you that he or she had seen fresh cow tracks in a field, the observations of a witness would be direct evidence which, if believed, would point to the presence of cow or cows on that property. This inference to be drawn from the observations would be circumstantial evidence that there were cows on that property. The law does not require that Mr. Ferlazzo's guilt be established by direct evidence alone, that is, by testimony of someone who actually saw Mr. Ferlazzo commit the alleged act or offense. One or more of the essential elements, or all of the essential elements, may be established by reasonable inference from other facts which are established by direct evidence testimony. Circumstantial evidence alone may be sufficient proof of the commission of a crime upon which to find a defendant guilty. The law makes no distinction between the weight to be given to direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should consider all of the evidence in the case and give it such weight as you think it deserves. Credibility of witnesses. You are the sole judges of the evidence. The credibility of the witnesses and the weight to be given to the testimony of each of them is up to you. In considering the testimony of any witness, you may take into account their ability and opportunity to observe, the manner and conduct of the witness while testifying, any interest, bias, or prejudice the witness may have, and the reasonableness of the testimony of the witness considered in the light of all the evidence in the case. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause you to discredit such testimony. Two or more persons witnessing an incident or transaction might see it or hear it differently. In weighing the effect of a discrepancy, consider whether it pertains to a matter of importance or to an unimportant detail. You may believe all the testimony of any witness, believe it in part and disbelieve it in part, or you may reject it altogether. You do not have to accept the testimony of any witness, even if it is uncontradicted. It is for you to say what you will believe and what you will disbelieve. Credibility of witnesses, police officers. In this case, you have heard testimony from police officers. You should consider such testimony in the same way that you consider any other testimony in the case. In evaluating the officer's credibility, you should use the same law you apply to the testimony of any other witness. As with any other witness, you may consider the officer's testimony in light of their training and experience. You should not give either greater or lesser weight to the testimony of a witness merely because the witness is a police officer. Expert witnesses. You have heard testimony from expert witnesses. An expert is a witness who has extra knowledge, skill, experience, training, or education about a particular subject. The value of an opinion given by an expert witness depends on their ability and upon the facts they use as the basis of their opinion. If the facts used by the expert are proven by the evidence, and if the expert is highly qualified, and if they are impartial, then their opinion may be of great value. On the other hand, if the expert's opinion is based upon one or more facts that are not supported by the evidence, or if the expert is biased or not qualified, then their testimony may be of little or no value. As with any other witness, you may accept all or part or none of the expert's testimony. You may give the expert's testimony whatever weight you think it deserves and consider it together with all other evidence. Defendant as witness. Mr. Ferlazzo has taken the stand and testified in this case. He has the right to testify if he decides to do so. You are to weigh his testimony the same way you weigh the testimony of any other witness. Defendant's statement. You heard testimony and viewed evidence that Mr. Ferlazzo made statements to Detective James Boris concerning the incident involved in this case. You must determine whether Mr. Ferlazzo made those statements and whether he made them voluntarily. Before you may consider any alleged confession, you must find that the state has proven beyond a reasonable doubt that the confession was voluntary. In other words, that it was the product of a free and deliberate choice rather than coercion or improper inducement. In assessing voluntariness, you should consider the totality of the circumstances under which the statements were made. You may consider such factors as the location, the other persons present, Mr. Ferlazzo's emotional state, and his personal characteristics. You may consider the statements to be voluntary if they were the product of Mr. Ferlazzo's free and rational choice. If you find that Mr. Ferlazzo's statements were not voluntary, then you may not consider them at all during your deliberations. If you determine beyond a reasonable doubt that Mr. Ferlazzo's statements were voluntary, then you should give them whatever weight as you think they deserve under the circumstances. Number of witnesses. The fact that one side may have called more witnesses than the other side is of no significance. Your task is to evaluate the credibility of the witnesses and to weigh all of the evidence. Exhibits. The exhibits which have been introduced are evidence, along with the testimony for your consideration. The court officer will take the exhibits to the jury room, and you may examine them in your deliberations. When you reach a verdict, you should return the exhibits to the court officer. Two kinds of exhibits: the magazine and live ammunition exhibit, and also the video and audio recordings, including Mr. Ferlazzo's recorded statements and the PowerPoint of the geolocation evidence, will not be in the jury room. To view these exhibits, please give a note to the court officer, and they will be played for you or viewed by you in the courtroom. Stipulation of fact. The state and Mr. Ferlazzo have agreed that you may find certain facts. These are called stipulations of fact and have been admitted as exhibits. As with any evidence in this trial, you must decide what weight you will give these stipulations. Use of electronic devices. Your verdict must be based solely on the evidence admitted during the trial. During your deliberations, you must not seek any information about this case from any outside source, including but not limited to television, newspaper, radio, cell phones, iPhones, smartphones, social networking sites, or any site on the internet. You also must not communicate by any means about your deliberations with anyone who is not a fellow juror. This includes tweeting, texting, blogging, emailing, posting information on a social networking site, or other website, or any other means of communication at all. Juror note-taking. During this trial, you have been provided with pen and paper, and some of you have taken notes. As I explained at the beginning of the trial, all jurors should be given equal attention during the deliberations regarding of whether or not they have taken notes. Regardless, of whether or not they have taken notes. Any notes you have taken may only be used to refresh your memory during deliberations. You may not use your notes as authority to persuade your fellow jurors as to what a witness did or did not say. In your deliberations, you must rely upon your collective memory of the evidence in deciding the facts of the case. If there is any difference between your memory of the evidence and your notes, you may ask that the record of the proceedings be read back. If a difference still exists, the record must prevail over your notes. Personal knowledge or experience of juror. In deliberating upon your verdict, you are not expected to put aside matters of common knowledge or your own observations or experience of the general affairs of life. You may use matters of common knowledge or personal observations or experience to evaluate the evidence presented at trial. You may use the knowledge and experience which you possess in weighing evidence and testing its credibility. However, a juror having special knowledge of a subject may neither state this knowledge to fellow jurors nor act upon it themselves in arriving at a verdict. You must not tell your fellow jurors about matters which are based on special knowledge concerning an issue in the case on trial, which did not come from the evidence received in the courtroom in this case. Burden of proof. The state bears the burden of proving Mr. Ferlazzo's guilt beyond a reasonable doubt. This means that the state must prove each of the essential elements of the charge beyond a reasonable doubt. This burden of proof remains on the state throughout the trial and never shifts to Mr. Ferlazzo. Mr. Ferlazzo does not have to prove that he is innocent. He is not required to call any witnesses or to present any evidence or to testify in his own behalf. Reasonable doubt. The state's burden is to prove Mr. Ferlazzo's guilt beyond a reasonable doubt. There is no precise definition of reasonable doubt. The state does not have to prove guilt beyond all possible doubt. A reasonable doubt is a doubt based on reason and common sense, which comes from a fair and rational consideration of the evidence or the lack of evidence in the case. It is not a vague, speculative, or imaginary doubt. Mr. Ferlazzo may not be convicted based on suspicion or conjecture. If you have a reasonable doubt, you must find Mr. Ferlazzo not guilty, even if you think that the charge is probably true. If after you have considered all the evidence and these instructions, you have a reasonable doubt about Mr. Ferlazzo's guilt, then you must find him not guilty. On the other hand, if you are convinced of Mr. Ferlazzo's guilt beyond a reasonable doubt, then you must find him guilty. Essential elements of the charged crime. Again, the state has charged Mr. Ferlazzo with first-degree murder as follows. Joseph Ferlazzo in the county of Chittenden at Bolton on or about October 16, 2021, willfully, deliberately, with premeditation, and with intent to kill, unlawfully killed a person, to wit, Emily Ferlazzo, by shooting her twice in the head. Every crime is made up of essential elements. Before Mr. Ferlazzo can be found guilty of the charge, the state must have proven each of the essential elements beyond a reasonable doubt. In this case, the essential elements are that on the date and at the place alleged, 1, Joseph Ferlazzo, 2, caused the death of Emily Ferlazzo, 3, the killing was unlawful, 4, Mr. Ferlazzo's killing of Ms. Ferlazzo was willful, 5, his killing of Ms. Ferlazzo was deliberate, and 6, his killing of Ms. Ferlazzo was premeditated. The first element is that Joseph Ferlazzo is the person who committed the alleged acts. The second essential element is that Mr. Ferlazzo caused the death of Emily Ferlazzo. The state must have proven that Mr. Ferlazzo's acts produced Ms. Ferlazzo's death in a natural and continuous sequence, unbroken by any efficient intervening cause. You must conclude that Ms. Ferlazzo's life ended by means other than natural causes, accident, or suicide. You must also conclude that, but for Mr. Ferlazzo's acts, Ms. Ferlazzo's death would not have occurred. Here, the state alleges that Joseph Ferlazzo caused the death of Emily Ferlazzo by shooting her twice in the head. The third essential element is that the killing was unlawful. The term unlawful killing means that Ms. Ferlazzo was killed without legal excuse or legal justification. Legal excuse or justification ordinarily refers to such things as self-defense or legal necessity. A killing may be justified where a person acts in self-defense. Here, the state must have proven that Mr. Ferlazzo did not act in self-defense. The fourth, fifth, and sixth essential elements require the state to have proven that Mr. Ferlazzo's killing of Ms. Ferlazzo was willful, deliberate, and premeditated. The mental state or intent with which a person does an act may be shown by the way in which they express it to others or by their conduct. In determining Mr. Ferlazzo's mental state or intent, you should consider all of the surrounding facts and circumstances established by the evidence. The fourth essential element is that Mr. Ferlazzo's killing of Ms. Ferlazzo was willful. A willful act is one which is knowing and intentional. You may find that the killing was willful if Mr. Ferlazzo killed Ms. Ferlazzo on purpose and not accidentally, carelessly, or unintentionally. The fifth essential element is that Mr. Ferlazzo's killing of Ms. Ferlazzo was deliberate. An act is deliberate if it is carefully considered. Mr. Ferlazzo must not have acted out of sudden impulse, but rather after deliberating for a period of time, however long or short. Deliberation is the act of thinking about and considering the reasons for and against an act or course of conduct. A person may think about killing over a period of months or over a period of seconds. Either period of time may be enough. The issue is the extent and quality of the deliberation, not its duration. Although also it is not enough to show that Mr. Ferlazzo had enough time to deliberate, the state must have proven that he actually thought about killing Ms. Ferlazzo before he did it. The last essential element is that Mr. Ferlazzo's killing of Ms. Ferlazzo was premeditated. A killing is premeditated if the actor thinks about it and plans it for some period of time before acting. Premeditation differs from deliberation in that it involves planning how to do an act, in addition to thinking about whether or not to do it. No specific amount of time is required. As with deliberation, a person may plan a killing over a period of months or over a period of seconds. Both may be premeditation. The issue is the extent and quality of the premeditation, not its duration. Again, it is not enough to show that there was enough time for premeditation. The state must have proven that Mr. Ferlazzo actually thought about killing Ms. Ferlazzo and planned it before he did it. To find Mr. Ferlazzo guilty of first-degree murder, you must find beyond a reasonable doubt that the killing was not done under great provocation or sudden passion that would cause a reasonable person to lose self-control and act without thinking, and as further defined in the remainder of the charge. The state bears the burden of proving all of the essential elements. If the state has not proven each of the essential elements of the charge beyond a reasonable doubt, then you must find Mr. Ferlazzo not guilty of first-degree murder. However, if the state has proven all of the essential elements beyond a reasonable doubt, you must return a verdict of guilty. Self-defense. Evidence has been introduced bearing on the issue of self-defense as justification for the use of deadly force by Mr. Ferlazzo. The state bears the burden of proving that the use of deadly force was unlawful. A use of deadly force committed in lawful self-defense is lawful and not a crime. Here, the state must have proven beyond a reasonable doubt that Mr. Ferlazzo did not act in self-defense. He has no burden of proof on this issue. A person has the right to defend himself when he is attacked or when he reasonably believes he is in imminent danger of being killed or suffering great bodily harm. A person in that situation has the right to use only such force as is reasonably necessary to repel the attack or the perceived imminent danger. A use of deadly force is justified by self-defense if, 1, Mr. Ferlazzo reasonably believed that he was in imminent danger of being killed or of suffering great bodily harm, and, 2, Mr. Ferlazzo's use of deadly force was reasonably necessary to repel the perceived threat. The right of self-defense does not require that the person actually be assaulted, but Mr. Ferlazzo must have believed that he was in imminent danger of great bodily harm, and his belief must have been reasonable under the circumstances. His expectation of harm must have been based upon fact and not on some imaginary fear. Furthermore, if he honestly and reasonably believed it was immediately necessary to use deadly force to protect himself from an imminent threat of death or serious bodily injury, the law does not require him to retreat. Self-defense requires that Mr. Ferlazzo must have had a reasonable fear of imminent harm. In deciding this issue, must consider what he knew about Ms. Ferlazzo at the time. You may consider their relationship history, including any aggressive or hostile acts by Ms. Ferlazzo, and any other evidence you consider relevant, including who started the confrontation. When assessing the reasonableness of Mr. Ferlazzo's fear, you may consider the individual characteristics of Mr. Ferlazzo and Ms. Ferlazzo, such as their respective size, gender, age, physical condition, strength, stamina, courage, and assertiveness. Self-defense permits only the amount of force that is reasonably necessary to repel the perceived harm. A person may use the amount of force that reasonably appears to be necessary under all of the circumstances known to them at the time. In this case, you must decide whether Mr. Ferlazzo reasonably believed it was necessary to use the amount of force that he did use. When a person has reasonable grounds to believe that an assault is imminent, he need not wait until it actually occurs before he may resort to self-defense. Once the issue of self-defense appears in the case, the burden is on the state to prove beyond a reasonable doubt that Mr. Ferlazzo did not act in self-defense or that the force used by Mr. Ferlazzo was excessive under the circumstances. Mr. Ferlazzo is not required to prove that he acted in self-defense. Again, all of the elements of the offense must have been present at the same time. If the state has proven each of the essential elements of first-degree murder beyond a reasonable doubt, then you will be done with your delivery. By means other than natural causes, acts death of Emily Ferlazzo by shooting her twice in the head. The third essential element is that the killing was unlawful. The term unlawful killing means that Ms. Ferlazzo was killed without legal excuse or legal justification. Legal excuse or justification ordinarily refers to such things as self-defense or legal necessity. A killing may be justified where a person acts in self-defense. Here, the state must have proven that Mr. Ferlazzo did not act in self-defense. The fourth, fifth, and sixth essential elements require the state to have proven that Mr. Ferlazzo's killing of Ms. Ferlazzo was willful, deliberate, and premeditated. The mental state or intent with which a person does an act may be shown by the way in which they express it to others or by their conduct. In determining Mr. Ferlazzo's mental state or intent, you should consider all of the surrounding facts and circumstances established by the evidence. The fourth essential element is that Mr. Ferlazzo's killing of Ms. Ferlazzo was willful. A willful act is one which is knowing and intentional. You may find that the killing was willful if Mr. Ferlazzo killed Ms. Ferlazzo on purpose and not accidentally, carelessly, or unintentionally. The fifth essential element is that Mr. Ferlazzo's killing of Ms. Ferlazzo was deliberate. An act is deliberate if it is carefully considered. Mr. Ferlazzo must not have acted out of sudden impulse, but rather after deliberating for a period of time, however long or short. Deliberation is the act of thinking about and considering the reasons for and against an act or course of conduct. A person may think about killing over a period of months or over a period of seconds. Either period of time may be enough. The issue is the extent and quality of the deliberation, not its duration. Although also it is not enough to show that Mr. Ferlazzo had enough time to deliberate, the state must have proven that he actually thought about killing Ms. Ferlazzo before he did it. The last essential element is that Mr. Ferlazzo's killing of Ms. Ferlazzo was premeditated. A killing is premeditated if the actor thinks about it and plans it for some period of time before acting. Premeditation differs from deliberation in that it involves planning how to do an act, in addition to thinking about whether or not to do it. No specific amount of time is required. As with deliberation, a person may plan a killing over a period of months or over a period of seconds. Both may be premeditation. The issue is the extent and quality of the premeditation, not its duration. Again, it is not enough to show that there was enough time for premeditation. The state must have proven that Mr. Ferlazzo actually thought about killing Ms. Ferlazzo and planned it before he did it. To find Mr. Ferlazzo guilty of first-degree murder, you must find beyond a reasonable doubt that the killing was not done under great provocation or sudden passion that would cause a reasonable person to lose self-control and act without thinking, and as further defined in the remainder of the charge. The state bears the burden of proving all of the essential elements. If the state has not proven each of the essential elements of the charge beyond a reasonable doubt, then you must find Mr. Ferlazzo not guilty of first-degree murder. However, if the state has proven all of the essential elements beyond a reasonable doubt, you must return a verdict of guilty. Self-defense. Evidence has been introduced bearing on the issue of self-defense as justification for the use of deadly force by Mr. Ferlazzo. The state bears the burden of proving that the use of deadly force was unlawful. A use of deadly force committed in lawful self-defense is lawful and not a crime. Here, the state must have proven beyond a reasonable doubt that Mr. Ferlazzo did not act in self-defense. He has no burden of proof on this issue. A person has the right to defend himself when he is attacked or when he reasonably believes he is in imminent danger of being killed or suffering great bodily harm. A person in that situation has the right to use only such force as is reasonably necessary to repel the attack or the perceived imminent danger. as a use of deadly force is justified by self-defense if, 1, Mr. Ferlazzo reasonably believed that he was in imminent danger of being killed or of suffering great bodily harm, and, 2, Mr. Ferlazzo's use of deadly force was reasonably necessary to repel the perceived threat. The right of self-defense does not require that the person actually be assaulted, but Mr. Ferlazzo must have believed that he was in imminent danger of great bodily harm, and his belief must have been reasonable under the circumstances. His expectation of harm must have been based upon fact and not on some imaginary fear. Furthermore, if he honestly and reasonably believed it was immediately necessary to use deadly force to protect himself from an imminent threat of death or serious bodily injury, the law does not require him to retreat. Self-defense requires that Mr. Ferlazzo must have had a reasonable fear of imminent harm. In deciding this issue, must consider what he knew about Ms. Ferlazzo at the time. You may consider their relationship history, including any aggressive or hostile acts by Ms. Ferlazzo, and any other evidence you consider relevant, including who started the confrontation. When assessing the reasonableness of Mr. Ferlazzo's fear, you may consider the individual characteristics of Mr. Ferlazzo and Ms. Ferlazzo, such as their respective size, gender, age, physical condition, strength, stamina, courage, and assertiveness. Self-defense permits only the amount of force that is reasonably necessary to repel the perceived harm. A person may use the amount of force that reasonably appears to be necessary under all of the circumstances known to them at the time. In this case, you must decide whether Mr. Ferlazzo reasonably believed it was necessary to use the amount of force that he did use. When a person has reasonable grounds to believe that an assault is imminent, he need not wait until it actually occurs before he may resort to self-defense. Once the issue of self-defense appears in the case, the burden is on the state to prove beyond a reasonable doubt that Mr. Ferlazzo did not act in self-defense or that the force used by Mr. Ferlazzo was excessive under the circumstances. Mr. Ferlazzo is not required to prove that he acted in self-defense. Again, all of the elements of the offense must have been present at the same time. If the state has proven each of the essential elements of first-degree murder beyond a reasonable doubt, then you will be done with your deliberations, and you must return a verdict that Mr. Ferlazzo is guilty of first-degree murder. Self-defense and lesser included offenses. If you conclude that the state has failed to prove beyond a reasonable doubt that Mr. Ferlazzo did not act in self-defense in the killing of Ms. Ferlazzo, then he acted lawfully and cannot be found guilty of any lesser included offense, and your deliberations are over. If you decide that the state has not proven each of the essential elements of first-degree murder, then you must consider whether Mr. Ferlazzo is guilty of one of the lesser offenses, or if you are unable to agree upon a verdict concerning the charge of first-degree murder, after all reasonable efforts to reach a unanimous verdict, then you may move on to consider the lesser offenses. Lesser included offenses. The lesser included offenses to first-degree murder are second-degree murder and voluntary manslaughter. There is no involuntary manslaughter in this case. The first three elements for all of the lesser offenses are the same as the first three elements for first-degree murder. Namely, the state must have proven that Mr. Ferlazzo, 1, that it was Mr. Joseph Ferlazzo, 2, caused the death of Emily Ferlazzo, and 3, the killing was unlawful. However, for lesser offenses, the state need not have proven that the killing was willful, deliberate, and premeditated. The mental states are different for each of the, and again, that's an error of the 2 lesser offenses. As you consider the mental state of the lesser offenses, You must also consider whether Mr. Ferlazzo's mental state was influenced by extenuating circumstances, such as sudden passion or great provocation that would have caused a reasonable person to lose self-control. Second-degree murder. The first lesser offense for you to consider is second-degree murder. If you reach the point of deciding whether or not the state has proven the lesser crime of second-degree murder, you must consider whether the state has proven the following essential elements beyond a reasonable doubt. That on the date alleged and at the place alleged, 1, Joseph Ferlazzo, 2, caused the death of Emily Ferlazzo, 3, the killing was unlawful, 4, in causing the death of Ms. Ferlazzo, Mr. Ferlazzo acted with an intent to kill or an intent to do great bodily harm or a wanton disregard of the likelihood that the death or great bodily harm would result. And 5, when he caused the death of Ms. Ferlazzo, Mr. Ferlazzo's mental state was not influenced by extenuating circumstances such as sudden passion or great provocation that would have caused a reasonable person to lose self-control. The first 3 elements are defined in the same way as they are for first-degree murder. The fourth essential element of second-degree murder is that in causing the death of Ms. Ferlazzo, Mr. Ferlazzo acted with 1, an intent to kill, or 2, an intent to do great bodily harm, or 3, a wanton disregard of the likelihood that death or great bodily harm would result. As you consider Mr. Ferlazzo's mental state at the time of the killing, you should consider all of the facts and circumstances, and you must decide whether the state has proven that Mr. Ferlazzo acted with at least one of the 3 mental states. A person acts intentionally if he or she acts purposely and not inadvertently because of mistake or by accident. You may find that Mr. Ferlazzo acted intentionally if it was his conscious objective to cause death or great bodily harm to Ms. Ferlazzo. The term great bodily harm means bodily injury, which involves a substantial risk of death, serious permanent disfigurement, or long-term loss or impairment of the function of any part or of an organ of the body. As used here, a wanton act is a reckless act done with extreme indifference to the probability that someone would die as a result. It is more than extreme negligence. The state must have proven that Mr. Ferlazzo was actually aware of the risk of death or great bodily harm, and that he ignored the risk. In determining Mr. Ferlazzo's state of mind, you should consider all of the surrounding facts and circumstances established by the evidence. The last essential element of second-degree murder is that when he caused the death of Ms. Ferlazzo, Mr. Ferlazzo's mental state was not influenced by extenuating circumstances such as sudden passion or great provocation that would have caused a reasonable person to lose self-control. Even if the state has proven the first 4 elements of second-degree murder, the presence of sudden passion or great provocation could mitigate the killing without justifying it altogether. Any person who is assaulted with violence or with an act of extreme insult may be provoked to a sudden impulse or anger which cannot be resisted until the person cools off. Words alone do not establish an act of extreme insult. If this person attacks their assailant and causes death, the killing may be found to be the result of anger or heat of passion. A killing is voluntary manslaughter and not second-degree murder if Mr. Ferlazzo was adequately provoked, did not have enough time to cool off, and in fact did not cool off, and if his inability to cool off within that time was reasonable under the circumstances. As used in this charge, the term sudden passion refers to such passion as would cause a reasonable person under the same or similar circumstances to act rashly and without reflection and deliberation. Sudden passion means that Mr. Ferlazzo acted or reacted from emotion, not from reason. Great provocation refers to a degree of provocation that would cause a reasonable person to lose self-control and to act without thinking. A mere annoyance or irritation is not enough. Words alone, no matter how offensive, insulting, or abusive, are not enough to reasonably provoke the use of deadly force. If there was sudden passion or great provocation, but not enough time passed between the provocation and Mr. Ferlazzo's alleged acts to allow a reasonable person to cool off, then the acts cannot be said to have resulted from sudden passion or great provocation. As to the last essential element of second-degree murder, the state must have proven that when Mr. Ferlazzo committed the acts that killed Ms. Ferlazzo, his state of mind was not influenced by sudden passion or great provocation that would have caused a reasonable person to lose self-control.
Judge, I think Dana has page 18 for
Yeah. Page 18 is missing.
the next page.
Thank you, Danny.
Are you also missing page 18?
I have 18.
None of us do.
You don't have 18.
We do now.
Huh. I get why. Okay. All of the elements of the offense must have been present at the same time. If the state has proven each of the essential elements of second-degree murder beyond a reasonable doubt, then you will be done with your deliberations, and you must return a verdict that Mr. Ferlazzo is guilty of second-degree murder. If you decide that the state has not proven each of the essential elements of second-degree murder, then you must consider whether Mr. Ferlazzo is guilty of one of the lesser offense, or if you are unable to agree upon a verdict concerning the offense of second-degree murder after after all reasonable efforts to reach unanimous verdict, then you may move on to consider the other lesser offense of voluntary manslaughter. I'm going to ask each of you to cross off "and involuntary manslaughter" that exists there if you have a pen, or at least do it in the jury room. And it was also on page 14, and please cross it off on the bottom of 14, second line after lesser included offense. And on the next page, it says 3 lesser offenses. There are only 2 lesser offenses. That was a mistake the court made. Voluntary manslaughter is a lesser offense than second-degree murder. It is an intentional, unlawful killing of another human being committed under extenuating circumstances that mitigate but do not justify the killing, such as sudden passion or great provocation that would cause a reasonable person to lose self-control. A killing is voluntary manslaughter as opposed to murder if Mr. Ferlazzo lost control because of the sudden passion or great provocation, if he did not regain control before the alleged killing, and if a reasonable person in the same situation would not have regained control within the same time. If you reach the point of deciding whether or not the state has proven the lesser charge of voluntary manslaughter, you must consider whether the state has proven the following essential elements beyond a reasonable doubt: that on the date alleged and at the place alleged, 1, Joseph Ferlazzo; 2, caused the death of Emily Ferlazzo; 3, the killing was unlawful; and 4, in causing the death of Ms. Ferlazzo, Mr. Ferlazzo acted with intent to kill, or an intent to do great bodily harm, or a wanton disregard of the likelihood that the death, or wanton disregard of the likelihood that death or great bodily injury harm would result. The first 3 essential elements are defined in the same way as they are defined for first-degree murder and for second-degree murder. The fourth and last element of voluntary manslaughter also contains the same 3 mental states that form the fourth element of second-degree murder. The state must have proven that in causing the death of Emily Ferlazzo, Mr. Ferlazzo acted with 1, an intent to kill, or 2, an intent to do great bodily harm, or 3, a wanton disregard of the likelihood that death or great bodily harm would result. You must apply the same definitions I have given you, and you must decide whether the state has proven Mr. Ferlazzo acted with one or more of these 3 mental states. At the same time, you may find that the degree of crime is reduced from second-degree murder to voluntary manslaughter if Mr. Ferlazzo's mental state was influenced by sudden passion or great provocation. The state bears the burden on this issue. If the state has proven the 4 elements that are the same for second-degree murder and for voluntary manslaughter, but if the state has not proven a lack of passion or provocation, then the state has proven voluntary manslaughter but not second-degree murder. In other words, the presence of sudden passion or great provocation can reduce the degree of crime from second-degree murder to voluntary manslaughter. However, if the state has proven the 4 essential elements of voluntary manslaughter, the presence of sudden passion or great provocation does not reduce the degree of crime below the level of voluntary manslaughter. All of the elements of the offense must have been present at the same time. If the state has proven each of the essential elements of voluntary manslaughter beyond a reasonable doubt, then you will be done with your deliberations. You must return a verdict that Mr. Ferlazzo is guilty of voluntary manslaughter. Presumption of innocence. This is a different take on it. When considering the degree of unlawful killing that might be involved in this case, the presumption of innocence plays 2 roles. First, Mr. Ferlazzo is presumed to be innocent of any crime. Second, if you find beyond a reasonable doubt that Mr. Ferlazzo committed an unlawful killing, then you must give him the benefit of any reasonable doubt in deciding the degree of the offense. In other words, you must apply the presumption of innocence and weigh it against the evidence at each step of your deliberations. Nevertheless, if all of the evidence weighed along with the presumption of innocence convinces you beyond a reasonable doubt that Mr. Ferlazzo is guilty of one of the higher degrees of unlawful killing, then you must find him guilty of the highest degree of offense that has been proven beyond a reasonable doubt. Verdict. Your verdict will be one of the four possible verdicts. Not guilty of any crime. 2, guilty of first-degree murder. 3, guilty of second-degree murder. Or 4, guilty of voluntary manslaughter. Concluding remarks. Jury deliberations. Your verdict must represent the considered judgment of each juror. To return a verdict of guilty or not guilty, you must all agree. Your verdict must be unanimous. You must consult with one another. You must try to reach an agreement if you can do so without sacrificing your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. Do not hesitate to re-examine your views and change your opinion if you are convinced it is wrong. But do not surrender your honest opinion as to the weight or effect of evidence solely because of the opinions of your fellow jurors or for the mere purpose of returning a verdict. If you need to communicate with me, you should send a note to the court officer signed by the moderator. You should not tell anyone how the jury stands numerically or otherwise until after you have reached a unanimous verdict and you have been discharged. Even then, you need not speak to anyone about this case unless you want to. When you have reached a verdict, tell the court officer that you have reached a verdict, but do not tell the officer what the verdict is. You will then be brought into the courtroom where I shall ask you if you have reached a verdict and if you have, what it is. And in this regard, you will get a special verdict form upon which to write it, which I'll describe in a minute. So before I talk about the moderator's duties, I can't know the moderator until I know who the jury is. And this is the sad time because you have all given such careful attention to the case that I must excuse 4 of you. So what I'm going to do, I'm going to go into chambers with the attorneys, and I have a little app on my phone that randomly selects. I've put in the numbers 1 through 16, and I push it 4 times. And wherever those numbers are, those will be the people who are excused. It's random. I am going to ask the first 2 people that I excuse, I'm going to ask you, you can go home, but I'm going to continue to admonish you not to discuss the case. In the unlikely event that the other 12 lose a juror for any reason during deliberations, I want the other 2 jurors to be ready to take over, and that can't work if in fact you discuss the case with anyone. So with that, I'll excuse us. We'll bring the microphone in. It will be on the record, but we'll turn off the like a sidebar, okay? And we'll be back very shortly. I ask you all to just remain seated, or if you need to stretch, to stretch.
We stand tall for truth, you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth, you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality we shout out loud. With justice here we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. Fight for love and endless grace. No one left out in the cold. Our troops are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth, you see. No chains of doubt, we're running free. Equality, we shout out loud. What justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the change. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our troops are brave, our stories told. Fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, Fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality we shout out loud. With justice here we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our troops are brave, our stories told. Fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth, you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break Fight for love and endless grace. No one left out in the cold. Our troops are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our troops are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. Fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality we shout out loud. With justice here we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our troops are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality we shout out loud. With justice here we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right Fight for love and endless grace. No one left out in the cold. Our troops are brave, our stories told. Fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth, you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our troops are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, Fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth, you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eye. Open eye that shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our troops are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality we shout out loud. With justice here we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eye. Open eye that shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the Fight for love and endless grace. No one left out in the cold. Our troops are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth, you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our troops are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality we shout out loud. With justice here we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality we shout out loud. With justice here we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. Fight for love and endless grace. No one left out in the cold. Our troops are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the change. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our troops are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth, you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity
we're back in the record in State versus Joseph Ferlazzo. It's about 5:40. There's a note from the jury. We've marked Court's Exhibit 1. It reads, Mr. Court Officer, may we please have a copy of the testimony with Joseph Ferlazzo being questioned by the defense? And it's signed the foreperson. We, of course, can't give a copy of the testimony. I will let them know that they can hear the testimony, but that would take 4.5 hours. So we'll see whether that is what they're really asking, or they want to narrow the request, or what they wish to do. But at this point, I'm not going to do any. I'll let them go back and tell us what they want. If they want the whole thing, they'll get the whole thing. They'll get it tomorrow, because I'm not going to do it tonight. As I mentioned, I really need to leave it around 6 tonight. So I'm going to bring them in now and explain we don't have copies, that we do have it in they can listen to it, but we certainly can't do that tonight. And if they still want to hear the whole 4.5 hours, they get to hear it. If they don't, then we'll see what they want to do with it. Okay?
Yes.
Seated. We have all 12 members of the jury present. We have the jury's note marked as Court's Exhibit 1 that reads, may we please have a copy of the testimony with Joseph Ferlazzo being questioned by the defense and signed by your foreperson, Ms. Reno. I don't know if you want a transcript. We don't have that. So if you want to hear the entire testimony, we can do that. The defense portion was about 4.5 hours. Or if there's more selective pieces that you were more focused on, that can be up to you. So we'll let you discuss that and let us know if there's something, whether you do want to hear the whole thing, that's perfectly okay. We won't do that today. We would do that tomorrow. In fact, whatever you want to hear, we'll probably do tomorrow, because today we need to retire by about 6 o'clock. So that the court has other things, unfortunately, it has to do this evening. So we can either, I think it would be good if you just at least had a little time to see if you exactly what you want, given this note and given the fact that we don't have a transcript of it. And if you know that, we can get another note, so if we're going to produce anything, we'll have it ready in the morning. Okay? So we'll ask you to retire and see if you want to do anything further.
May I answer? We do know the specifics that we'd like, so.
Okay. Why don't you write it in a note so that we have it specifically, and then get it back from you, okay? Just so we have a record of it. Why don't you hang around for just stay, will be, I assume, a couple of minutes. Court's Exhibit 2 is a note saying, may we please review the defense attorney questioning Mr. Ferlazzo. The specific time period we would like to review is when the defense is asking Mr. Ferlazzo to recount the events of Friday night from around the time period after Nicole and Ariel leave the camper until breakfast.
That's fine. My only request is that I may have asked him about that on more than one occasion, and I want to make sure that they hear all the testimony he made. So I don't,
We'll see what
that's
we can
my
do.
request. He may have testified about it on more, as you know, as you just
Somebody in your
said, 4.5
staff
hours.
should have notes of the events, I would think.
I don't have any timestamp, and I don't have, the court's in the best position to review the
See what we can
4.5
do.
hours.
We're not going to do this tonight.
I'm sorry?
We're not going to do this tonight.
Okay, no, I know that.
But
I'm
we'll
just
look,
asking,
we'll
they've
look
asked for a
through what we've
specific
got.
time period, and I'm saying that it may, he may have testified about this time period on more than one occasion over the 4.5 hours, and I want to make sure they hear all of his testimony.
All right. That would include any texts he wrote. I think you would have talked about that too. I don't know if you did initially.
I may have. Could the court read their note again, please?
Yeah. The specific time period, I'm going to just read part of it.
Yeah.
Specific time period we would like to review is when the defense is asking Mr. Ferlazzo to recount the events of Friday night from around the time period after Nicole and Ariel leave the camper until breakfast.
Until breakfast, okay. So that narrows it down. My request, I will just say again, is that he may have testified about that time frame more than once over the course of the direct testimony, and I want to make sure they hear all his testimony about that.
I've heard you.
Thank you.
Okay. Let's get them in because we'll tell them we'll try and get it in the morning. Probably ask him to get here around 8:30, but let's get him in the courtroom. Please be seated. We have your more specific note, which reads, it's Court's Exhibit 2. May we please review the defense attorney questioning Mr. Ferlazzo. The specific time period we would like to review is when the defense is asking Mr. Ferlazzo to recount the events of Friday night from around the time period after Nicole and Ariel leave the camper until breakfast. That gives us a pretty clear idea. It will take us a bit of time to get that, which suggests to me it's probably a good time to adjourn for the day and let you come back fresh tomorrow. We'll, in the meantime, try and get the testimony that you are requesting. It may be not all in one chunk. There may be other things, so it'll take a little time to see if there are places other than in one full period where it is, or whether there's other times that time period is discussed. So in the meantime, have a good night tonight. Please, most important now, not to discuss the case with anybody or to look at any media or any device which might broadcast this. It's critical that you just discuss this case with each other and learn nothing else about the case except what you already know from the evidence in the courtroom. Okay? So good night. I'll leave it to you. 8:30 or 9, would you like to start? 9. 9 o'clock. All right. We'll see you then. Anything else before we depart tonight?
No, thank you.
Okay. See you in the morning.
We stand tall for truth you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing